Peace, everyone. Welcome to the Moroccan School of Government and International Law. We have a wonderful class for you today. This is the Moorish Treaty Protection and Consular Relations series, Writ of Quo Warranto, Affidavit and Complaint. We have a sample of Writ of Quo Warranto sample. All right, so this is actually was actually presented about 6 weeks ago, and we just will continue with this lesson here. And so once again, the Moroccan School of Government International Law really thanks all of you for your support. All right, so don't forget to like, subscribe, hit that notification button, the Moroccan Post Media YouTube page. Next slide, Moroccan Post Media YouTube page. All right, definitely click like, subscribe, hit that notification. Right, so as you see here, the Moroccan Post Law, Government, and History classes. We have speakers today, Shem Malachi Bey, the Moroccan Treaty Protection and Consular Relations and Affidavit and Complaint, Writ of Quo Warranto. Right, so share, you can so let other people know about the classes. All right, once again, the Moroccan Post Media YouTube page. Click like and subscribe. Next. We have my books, my Moorish Treaty Protection and Moors and Masonry Part 1, Illuminati and Illumination of the Mind, the Masonic Compass Square and the connection of timekeeping and measurement, how her Venus and Moon rule, etymology and vocabulary, submit to 1, and available now, Moors and Masonry Part 2. Moors and Masonry Part 2, go to moorsandmasonry.org. Once again, moorsandmasonry.org to order your books. All right, so we have my moorsandmasonry.org is available now, as I stated. It's Moors and Masonry Part 2, the power of Moorish treaties and the recovery of lost Moorish sovereignty. 395 page book. All right. In there we have the Shem Malachi Bey, the Shem Malachi Bey's plan. The Shem Malachi Bey's plan is chapter 8. You see the Shem Malachi Bey's plan. In fact, you see here the Shem Malachi Bey's plan. Chapter 8. Can everybody you want me to see me? All right, so the Shem Malachi Bey, Chapter 8, Shem Malachi Bey's proposal and plan for the restoration of Moorish national political unity based in the ancient, well-settled international law principles of restoration of post-millennium, reversion to sovereignty, and the recovery of lost sovereignty. Primary goal, resuscitating the Moroccan Empire out of her political coma, prolonged unconsciousness, political inactivity, and absence from the family nations, bringing the Moroccan Empire out of her 200-year period of political collapse, disintegration, dismemberment, and the absence from the family nations due to European conquest, subjugation, slavery, colonization, captivity, bondage, and the mass denationalization of native Moors of the land. The restoration of the Moroccan Empire to independence and full sovereignty, and through the enforcement of post-millennium. All right, so once again, Shem Malachi Bey's proposal and plan for the restoration of Moorish national political unity based in the well-settled international law principles of restoration, post-millennium, reversion to sovereignty, and recovery of lost sovereignty. This is chapter 8 of Moors and Masonry Part 2. All right, before we go on, I want to read, Shem hasn't, I forgot to give Shem a book. My apologies, Shem. I forgot to give Shem a book on April 8th, the book signing. All right, so Shem does not have this. It's my fault. I apologize to Shem Malachi Bey, my man. All right, that's why Shem is, we were so busy that day. Acknowledgement, Shem Malachi Bey. I want to express my great honor, respect, and appreciation to Shem Malachi Bey for teaching me how to study the law of nations, public international law. Moorish bilateral treaties between the 1500s and 1800s, international acts, international conventions, and international agreements. Shem's teaching methodology has enabled me to bring the Moorish bilateral treaties with France, England/Great Britain, Dutch Republic, Netherlands, Sweden, Spain, Portugal, Sardinia, Denmark, Belgium, and United States from the 15 to 1800s outlined and discussed in Moors and Masonry Part 1 and Moors and Masonry Part 2, the power of Moorish treaties and the recovery of lost Moorish sovereignty to life in present political application. So this is the announcement, and to Shem Malachi Bey, I greatly appreciate the brother and great honor. I've unwrapped my turban and tip my fez to Shem Malachi Bey. So go to moorsandmasonry.org to get your copy of Moors and Masonry Part 2 as well as the other books. We have the objective of the Moroccan Post School of Government and International Law. Amanda.
The objective of the Moroccan Post School for Government and International Law. The Moroccan Post School for Government and International Law's main objective is to facilitate the national political unity of the various Moorish governing bodies into a Moorish intergovernment alliance and Central Moorish Imperial Parliament Council. The ultimate goal of the Moorish Intergovernment Alliance would function as a Moorish provisional government, transitional or temporary government, to provide international representation and an international voice for our people who, in large numbers, are currently subjugated under an apartheid United States system of legalized slavery, evidenced through the mass denationalization of the original autochthonous, native, aboriginal, indigenous people of the land. Furthermore, this provisional transitional Moorish government would facilitate a temporary transitional Moorish government structure to use diplomatic channels and international law to engage in diplomacy with the European nations with which we, the native Moors of the land, have treaties so as to stay in unity with the treaties as the laws of the land and in honor with international treaties, agreements, covenants, declarations, unions, and conventions of indigenous Aboriginal people that formed the compact with each other, and along with treaties signed with Great Britain, France, Spain, Portugal, England, Great Britain, Sweden, the Netherlands, Dutch Republic, Belgium, Denmark, Sardinia during the 1500s, 1600s, 1700s, and 1800s, and the de jure United States Republic of America in 1787 and 1836 as the ruling principle and norms of the law. The Shem Malachi Bey's proposal and plan for the Moroccan Post School for Government and International Law, an educational vehicle used to navigate the various Moorish bodies' politic into one interpolitical central governing body. The Moorish Post School for Government and International Law is the educational vehicle to facilitate the Shem Malachi Bey's proposal and plan by developing curricula to educate our people, the Moors, in political science, constitutional and governmental principles, international law, including diplomacy, consular relations, capitulatory extraterritorial consular jurisdiction, central authority, consular notification, treaty enforcement, recovery of lost sovereignty, reversion to sovereignty, and post-liminium, thereby facilitating the national political unity of the various Moorish governing bodies into one central Moorish Imperial Parliament Council. The ultimate purpose of the Shem Malachi Bey's proposal and plan, facilitated through the Moorish Post School for Government and International Law, is to restore our Moroccan imperial government structure and therefore position ourselves politically to function the sovereign power once controlled by the past Moroccan Moorish emperors, beys, deys, pashas and bashas, caliphs, and emirs. By reclaiming our inherent pre-existing sovereign power and self-determination rights, we will be able to provide international representation and an international voice for our people, the Moors, who in large numbers are currently subjugated under an apartheid United States system of legalized slavery, evidenced through the mass denationalization of the Aboriginal indigenous peoples of the land. Furthermore, the Moroccan Post School for Government and International Law is educating our people, the Moors, on the Shem Malachi Bey's proposal and plan to prepare our people to implement government structures in their various communities. The knowledge of international law, political science, constitutional and government principle, and our history will place us in a stronger political and educational position to use diplomatic channels and international law in restoring our diplomatic relations with the European nations with which we have treaties. This will position us politically to stay in unity with the treaties as the law of the land and in honor with international treaties, agreements, covenants, declarations, unions, and conventions of Indigenous Aboriginal peoples that formed the compact with each other and along with treaties signed with England/Great Britain, France, Spain, Sweden, the Netherlands, Dutch Republic, Denmark, Sardinia, Belgium, and the de jure United States Republic of North America as the ruling principle and norms of the law. Shem Malachi Bey's proposal, outline, and strategic plan for facilitating political legitimacy, the consent of the people, and the will of the people among the Moors through structured education, large-scale community outreach, and networking. A, Treaty of Liberty. B, Moorish Imperial Parliament Council. C, Letter of Political Legitimacy. D, Government Proclamation. E, Executive Order. F, Political Legitimacy as a basic condition for legitimate government. G, How we come to salvation and redemption from the European doctrine of discovery, Inter Caetera Divina of May 4th, 1493, conquest and subjugation. H, restoration of international recognition and the reversion to Moorish sovereignty. I, addressing the subjugation of Moors under the United States legislation of the 14th Amendment of 1868. Letter of termination of presumption and assumption that Moors are citizens of the United States and residents of the states in the Union. J, political behavior and the people's participation in government outline. K, Moorish body politic formation structure. L, Moorish body politic formation, constitutional and government principles course, 12 classes. M, Moroccan Post School for Government and International Law. N, Moroccan Post Media. O, Moroccan Post Newspaper. P, Masonic Outreach and Masonic Gate Newspaper.
All right, this outline is in chapter 8. And what Amanda read above, the objective of the schools in chapter 8 of Moors and Masonry part 2. All right, so next we're going to go to Shem's statement to the people, which is in chapter 8. I'll read the statement. Shem's statement to the people is in chapter 8 of Moors and Masonry part 2. All right, Shem Malachi Bey's proposal for a call for the restoration of national Moorish political unity through political legitimacy, consent of the people, large-scale community outreach, and network. Shem Malachi Bey's public statement to the people. Greeting. My proposal and plan for the restoration of national Moorish political unity is rooted in the past structures of ancient governments. The proposal and plan for restoring national political unity among our people, the Moors, most of whom are classified as Black, Negro, Colored, African American in the United States Census Bureau, is to facilitate political unity, consent of the people, through large-scale community outreach and network. This large-scale outreach approach to unconscious Moors and the network among conscious Moors having political bodies are vital to contribute to the formation and expression of the will of the people. Having a network vehicle that creates the space for the formation and expression of the will of the people is a fundamental principle to facilitating good government and the basis to political legitimacy. The political action of Moroccan Moorish political bodies coming together to form a central governing body composed of many Moorish body politics to function as a Moorish national provisional temporary governing body to serve as a voice for our people in the international arena is much needed to address the systematic generational mass denationalization and subjugation of our people, the Moors, as well as the generational European colonization of lands known to the world as of our lands known to the world as North America, South America, Central America, and Americana. An interpolitical constitution will be formed from our Moorish political governing bodies by sending up representatives elected by the Moorish Moroccan people or by supreme authority who will exercise collectively the sovereign power and authority in a provisional capacity that the Moorish beys, emirs, caliphs, pashas, and bashars, indigenous Aboriginal people, operated in unity with Moorish emperors, sultans, once exercised before the dismantling of our Moorish empire and the usurpation of our Moorish sovereignty due to conquest, subjugation, and colonization by the Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of England / Great Britain, Kingdom of the Netherlands, Dutch Republic, Kingdom of Sweden, Denmark, Sardinia, and Belgium. When the sovereign power of an empire, kingdom, or nation that ruled over a host of kingdoms or provinces in their territorial domiciles diminished, the people of the empire, kingdom, or nation possess the inherent and divine right to resort to the international law nation principles of post-millennium, reversion to sovereignty, recovery of lost sovereignty, self-determination, and autonomy. When Moorish emperors relinquished their sovereign power over the Moorish kingdoms in the territorial domiciles they once controlled, we the Moors have a right to govern among ourselves and form an interpolitical assembly with an interpolitical constitution that would act or take the place of the sovereign power that the Moroccan Moorish emperors once claimed. The interpolitical constitution will be the structured governmental body that regulates authority over all the Moorish political politics states, that the structured language and the interpolitical instrument. The interpolitical constitution will position us politically to reestablish diplomacy and consular relations with the Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of England, Great Britain, Kingdom of the Netherlands, Dutch Republic, Kingdom of Sweden, Denmark, Sardinia, and Belgium, with which we negotiated treaties during the 1500s, 1600s, 1700s, 1800s. The Moorish treaties prove that the names Morocco and Moor were predominant names that dominated the military engagement wars, commercial, trading, mercantile, merchant, seafaring, diplomatic, and consular strategies, captivity and ransoming strategies of the Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of England, Great Britain, Kingdom of the Netherlands, Dutch Republic, Kingdom of Sweden, Denmark, Sardinia, Belgium between the 700s and 1800s. The enforcement of the ancient international law principle of restoring a people held against their will to their original condition before being placed in slavery, subjugation, servitude, captivity, and bondage, known as post-millennium, will place our people on the proper road to recover our Moorish lost estates, inheritance, land rights, natural resources, sovereignty, treaty protection, placed in the family of nations, nationality, names, history, languages, genealogy, ancestral festivals, clothing, holidays, rituals, dances, ceremonies, celebrations, ceremonies, philosophy, and science of healing with the use of sound and herbs, and the science of astronomy, the laws of the stars. The United States Emancipation Proclamation 1863, the 13th Amendment 1865, 14th Amendment 1868, and 15th Amendment 1870 have been used as political tools to disguise the continuation of slavery, subjugation, and captivity of our people. These United States legislation during the 1860s do not constitute the enforcement of the international law nation's remedy of restoring and returning a people held against their will under the condition of slavery, subjugation, servitude, captivity, and bondage. Post-millennium is the international law principle of restoring and returning a people to their original condition before captivity, slavery, and subjugation. It is evident that the United States Emancipation of 1863, 13th Amendment, 1865, 14th Amendment, 1868, 15th Amendment, 1870, have not restored and returned us to our original condition before captivity, slavery, and subjugation. The United States has committed human rights violations by the generations of systematic mass denationalization of our people. The United States does not have a structured foundation set up to rightfully and properly place in a census, transmit the natural living being after birth of the indigenous Moroccan Moorish consanguinity and their system of records to protect and safeguard the natural living beings' nationality and birthright. The provisional temporary government will allow for the felicitation and formation of expression of the will of the people and political legitimacy as the path to permanent government and the re-entering the family of nations under the reversion of sovereignty as an old and original state. This political structure will position us politically to effectively address the United States human rights violations by the generation of systematic mass denationalization of our people and the disguising of the continuation of slavery under the Emancipation Proclamation 1863, 13th Amendment 1865, 14th Amendment 1868, and the 15th Amendment 1870 to the international community of nations, family nations. People used in a political sense is the repository of the sovereignty of the people and a source of government power. I propose, that is Shem Malachi Bey, a plan to facilitate the restoration of the exercise of this inherent sovereign power that embodies the collective unity of our people operating in political government structure. It is vitally important to facilitate a political process whereby our people who still remain unconscious and classified as Black, colored, Negro, and African American in the United States Census Bureau in the Commerce Department can be a part of the will of the people once they become conscious of their Moorish nationality and birthright. A political process that does not facilitate the formation and expression of our people who are unconscious of their Moorish nationality and birthright is not aligned with the principles of political legitimacy, the will of the people, the consent of the people, self-determination, and good government. Moors and Masonry Part 1 is the extensive research and study in the history of Moorish treaties, military engagements, wars, captivity, ransoming strategies, diplomacy, conciliations between the Moroccan Empire, including Algiers, Tripoli, and Tunis, and in the European kingdoms, Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of England / Great Britain, Kingdom of the Netherlands, Dutch Republic, Kingdom of Sweden, Denmark, Sardinia, and Belgium during the 1500s, 1600s, 1700s, 1800s. Let us reconnect to our ancient knowledge of divine law, the unseen and visible world, and natural law, as expressed by the all-seeing eye, by restoring our ancient knowledge of universal law, mentalism, of universal law, mentalism, cause and effect, correspondence, polarity, gender, rhythm, and opposite duality, as well as our ancient knowledge of geometry as the blueprint of creation, as expressed symbolically as the compass square with the G in the center, and the geometric shapes on stained glass windows of churches, mosques, and synagogues. All right, coming up in September, Ateker Kingdom Alliance presents Ateker North America Convention 2023 in Atlanta, Georgia, from September 20th to September 26th, in New York, September 26th to September 30th. Registration is $250, payable to those accounts you see below. All right, so we have the email info@atekerkingdomalliance.com, website www.atekerkingdom.com. You have the contact information, U.S. also known Administrative Secretary Sarah Capers, 718-288-9609. Convener General, aka HRA Akjul Ampong, 413-519-5149, and Africa Office Sarah Alugat, 256-782-72407/ and also 256-787-406-400. All right. So just we have the flyer up there. Once again, this is the Ateker Kingdom of Alliance presents Africa, Ateker North America Convention 2023. This is Shem Malachi Bey and Abdullah Bey. This is on the write-up for the GoFundMe. This is the write-up for the GoFundMe. When you click on the GoFundMe, you'll see the you'll see this. All right, so I'm going to read this. Shem Malachi Bey and Abdullah Bey, Abdullah Mosi Bey, the liaisons between the Moors and Moroccan Empire, and the brothers and sisters to the Ateker Kingdom Alliance, 700 Kingdoms in Africa, have been invited to speak at 2023 Harnessing Diaspora Current Economic Development Summit and Ateker Kingdom Alliance North America Convention held in Atlanta, Georgia from September 20th to September 25th, and in New York City during the United Nations General Assembly from September 26th to September 30th. The Shem Malachi Bey plan aligns with the Ateker Kingdom Alliance's objective of recovering the lost sovereignty, restoring the native people's blood right ties to the lands, and ending the centuries of European colonization and mass denationalization. They will be accompanied by two assistants, Writ of El Bey, secretary to Abdullah Bey, and secretary to the Moroccan Post School for Government International Law, who will be responsible for taking notes, posting pictures on Facebook Live, and writing reports. Terrence Bey, the administrator of the Moroccan Post School for Government International Law, will be responsible for transportation, video, and photography, and will also give live up-to-date reports on Facebook Live and YouTube. Our purpose is to restore the lost Moorish sovereignty by promoting Shem Malachi Bey's proposal, which is to restore national political unity to conscious and unconscious Moors, most of whom are classified as Black, Negro, Colored, and African American in the United States Census Bureau and on all official documents. This is to facilitate political legitimacy, the free will of the people, and the consent of the people through large-scale education, community outreach, and network. In addition, the funds will be used to build a legal library to include international law books, political science, political philosophy, and political and economic infrastructure books. We are writing to request your assistance in reaching our goal of raising $8,000 by August 15, 2023. Your donations will position us to address the following issues at the Ateker Kingdom Alliance North American Convention: generations of mass denationalization of our people, European colonization of our land, and linguistic genocide perpetrated among Moors for centuries. Furthermore, the plan will facilitate the formation and expression of free will and consent of our people and educate unconscious Moors and their Moorish nationality, blood ties to the land, history, and culture. Your kindness will give hope to many individuals and families as we restore our presence on the international platform. Thank you in advance for your consideration, and we hope that we can count on your support to advance our cause. All right, next.
Attica Kingdom Alliance, April 12th, 2023. During the chair, Your Excellencies, Udamakia, as Africa Kingdom Alliance Royal Ambassador at Large, this official letter of recommendation is on behalf of Moorish, Ambassador of Mexam, Honorable Abdullah El Tali Muzi Bey, Moorish ambassador, to sit at the table in our discussion of the Moors of Amexa/America with the Attica Kingdom Alliance and the One, Alkebulan today, tomorrow, forever. Abdullah El Talimuzi Bey, Moorish representative to the Attica Kingdom Alliance, will serve in a non-political capacity as a liaison to educate the 750 kingdoms that embody the Attica Kingdom Alliance. As a Moorish representative, he will facilitate dialogue on political issues regarding the autochthonous, original, native, and indigenous Moors. The Moors have been classified for generations as Black, Negro, Colored, African American, Indian, Spanish, Latino, and Hispanic on the United States Census and on other official documents used in United States jurisdiction. Abdullah will address the primary issue of mass denationalization of the Moors. He will also educate the Attica Kingdom Alliance on the centuries of European colonization of Moorish lands, mass incarceration, linguistic genocide, medical apartheid, mass imprisonment, subjugation by the Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of Great Britain, Empire of Netherlands, Denmark, Sardinia, and Belgium from the 1500s to the present, and by the United States from 1789 to the present. Our objectives and goals are aligned with the Attica Kingdom Alliance. This conference is an opportunity to collaborate and establish ongoing relationships with the Attica Kingdom Alliance to address the above issues and to facilitate liberation for millions of Moors in North America, South America, Central America, and for our sisters and brothers on the continent of Africa. On behalf of the Crown of Attica, Makakuvu Ali El Bey, Africa Kingdom Alliance Royal Ambassador at Large.
All right. Makakuvu will be with us tonight, along with another representative of the Attica Kingdom Alliance at 9 o'clock. He will explain his position and also fulfill questions. So he'll be on at 9 o'clock, along with another representative of the Attica Kingdom Alliance. We have the GoFundMe link. Joe will put the GoFundMe link in the chat. Is that it right there? Right? We read everything. Has everything been read?
Mhm.
That's everything.
Yes.
All right. I thought it was something else after that.
No. Can you still see my screen?
Yeah, there's something. Yeah, yes, there was something else. The last thing is the long term, short term.
And that's it right here.
That's it. And then we'll go on. Here we go. So just want to get this in. Short term survival approach versus long term strategic planning approach. Short term survival approach, no strategic planning, no goals and objectives, no facilitation of the recovery of lost sovereignty, more statehood, re-entering the international community of the nations under the recursion of sovereignty as an old and original state, and reestablishing of diplomacy of the European kingdom with which we negotiated treaties from the 1500s to the 1800s. No plan to command the enforcement of post-millennium as to address Pope Alexander's papal decree of Intica Terra Divina of March 14, 1993. So this long-term strategic planning approach does indeed address that, and that's the Shem Malachi Bey's plan is a long-term strategic planning approach. We're not talking 100 years, we're not talking 10 years, all right? But we need a strategic plan, all right, The plan is in chapter 8, chapter 8 of Moors and Masonry part 2. All right, and it will also be placed in a separate book. All right, so we're going to
Abdullah, you with me,
we have a
Abdullah?
reader, complaint, void judgment, and for writ of Quo Warranto. Can you hear me?
Yeah, I can hear you.
Someone just called me, so I didn't.
You with me for a minute, Abdullah.
What about now?
You good? I can hear you good. You good? You back on?
Somebody called. Somebody was calling. That's why. All right, complaint to void judgment and for writ of Quo Warranto, State of Mexico, ex-rel Kenneth Gomez, plaintiff. Can we have a reader? By serious.
Yes, sir.
All right, you like to read?
Actually, I'm driving, brother.
All right, so no. All right, who would like to read?
I'll
see
read,
what
and
I
I don't
got.
know if Terrence is on or if Joe is in charge, but Yannick
Joe's
is
in charge.
asking.
Yeah, Joe's has, yes. I gotta call somebody. Someone just
Yannick
called
is
me.
asking to be let in. I don't know if he's in the waiting room, so I'll go on. Okay, complaint to void judgments and writ for Quo Warranto. State of New Mexico, ex-rel Kenneth Gomez.
Hold
Plaintiff-
on, Amanda. Amanda,
Okay.
let hold on, Amanda. Joe, let OJ in. OJ's trying to get in. OJ and somebody else. He just text me. Let us in.
I did. I let them in.
All right. Everybody good. All right, good.
Okay. Complaint to void judgments and writ for Quo Warranto. State of New Mexico, ex-rel Kenneth Gomez. Plaintiff versus 11th Judicial Court defendant. Comes now plaintiff Kenneth Gomez for the state of New Mexico under authority of section 484-3-4 NMSA 1978, since there are no public officers required by said law who would or could grant permission to Gomez, and under authority of Rule 1-060B 4, claiming the judgments and decisions involving him during times relevant from the year 1963 to the present, issued by any and all the courts within the jurisdiction of the defendant 11th Judicial District Court, hereinafter defendant District Court, have severely injured him by denying him constitutional rights under sections 1 and 3, 14th Amendment, and all civil rights laws giving the said constitutional powers effect. In addition, said decisions and judgments have damaged his personal character without recourse, since there are no persons who have acquired title to positions as judge in any state of New Mexico courts of law, and since there are no courts of law to which he could appeal, and the non-competent judgments rendered, see Orozco versus Cox, 75 NM 431-405, P2D 668, 1965 for definition of competent court. Said judgments and decisions have all been null, void, and without legal effect at their inception, as repugnant to both constitutions. Marbury versus Madison, 5 U.S. 137, 178, 180, to wit, respectively. So the law to be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must decide that the case conformably to the law, disregarding the Constitution, or conformably to the Constitution disregarding the law, the court must determine which of these conflicting rules governs the case. This is one of the very essence of judicial duty, and at 178, and thus the particular phraseology of the Constitution of the United States. Can you go back up, Joe? Of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. at 180.
All right,
Section
Can I,
1,
can I say something before we go any further?
yes.
So we go into the Quo Warranto. See, when you look at the body of an instrument, first of all, he's a citizen of Mexico. He been convicted in the United States political jurisdiction in violation of a treaty. That's all. Now, when a treaty violation happens, the only person to the treaty, if a treaty does not allow each government to assert jurisdiction over their national, then that means that it falls to the council's jurisdiction under international law. So that means that the first time he cannot come in place of the state, watch him, because he was not elected as a public official of the state. He's a citizen of that government, that state, that country, but he cannot come into place as a government official representing the state. This is a bad misconception that been going on for a lot of years, decades, that individual come in place of the state. No, they can't, because they're not elected. A person that represents the state is elected as delegate authority, as a government official. When you say you come in place as a state, that means you're taking the usurping authority as if you're a government official of the state. Now, on the foreign affairs, whoever the state designate the governor of foreign affairs, that's supposed to be making the Quo Warranto. It don't make it to a foreign court. You make it to the council. The council sets up a council jurisdiction and goes to the high authority that's been delegated authority to the world authority, to the central authority of the government, between governments. They operate through what? The council jurisdiction operates through evidence, letter of rogatories. When that happens, and the council make a decision, the council put his council seal on it being final. It can't be appealed to no either government at all. The council goes to that foreign government based on their constitutional law and say, wait a minute, we got a judgment against one of your political jurisdictions, a county or a state. They go to the high court and say, listen, we need to force this council seal, this council adjudication that falls on international law. What that court does, the high court of that land, he bypassed all the other courts because he can't go to them because they're a child of the government. It was created by the government structure of that legislative body. He had to go to the Supreme Court of that land and say, wait, I got to force this judgment. By international law, you have authority to assist me in enforcing the judgment. What you mean? You have to file a writ of assistance to the high tribunal court to enforce that what? That writ. Now this writ is supposed to go not to the courts. The writ is supposed to go to the government body, International Department of International Affairs, the high government power. That means like Congress. You got a Congress of the United States. A writ of this magnitude, a council for that government supposed to follow a writ before the international community of that government, the international affairs. Whoever the officer is that delegating the authority is the only one that can hear that writ, meaning that he's telling that other government power that your courts exercise jurisdiction in the matter of international law that was not delegated to them. That government body, that Congress of that state, could turn that judgment over with a legislative act. Yes, they don't teach you this. You don't need a court. When it comes to international treaties being violated, you don't need a court to rule. The Congress, to ratify all treaties, consent to all treaties. The president and Congress can grant their writ, exercise the writ authority on international law, and let that national go free. What you mean, Shem? Grant him clemency and release him from custody on a habeas corpus because he's illegally detained by a judgment of a court that they have authority. See, where there's no jurisdiction to hear something, what you mean, Shem? They was never delegated any authority in their own constitution to hear a foreign matter. Neither was it given any power in the treaty. When the two governments met together, they never gave that government power, never legislative power to give to that court power to rule on their nationals. So that judgment becomes because that court, the issue of that judgment, never had authority to do it. The only way to correct that, really, you can't go to the court. You go to the legislative power. That's why if a treaty is not ratified by Congress and signed by the president, it cannot be committed in the law as a self-executing instrument. What you mean, Shem? That means if it's a treaty signed and the foreign affairs of one government tell the United States, say, listen, we have not stipulated in the treaty, we have stipulated to the treaty diplomatic channels for a council. What happened is that they would do a resolution when the government was signed that it stipulate that if anything happened in national law, that a council will be the one that will hear that matter. In this case, so we get clarity on it, that he was not supposed to file in the place of his country as a government official. Say he represents the state. He did not represent the state. He was not delegated authority to represent the state on an international claim. He's a regular citizen. His counsel is supposed to do that. His counsel, officer on the international affairs, or the ambassador is supposed to be the one to step up and make this high claim, not to the courts. See, this is a structure violation. It's supposed to go before the legislative powers that make the law. Because just like that judge, the court found him guilty, the legislative power can pass a legislative act and say that's unconstitutional and grant him amnesty. And grant him amnesty. Amnesty means clemency. That means that we forgive you on this conviction because that court never had jurisdiction to try you. Because we never delegated them authority on international law to make decisions on international matters. Under international law, there's nothing in the Constitution or legislative act giving that court power to hear international matters or foreign nations. There's nothing. The treaty is the only legislative act you got. Self-executing contract that they can use, nothing else. So we analyze the case, analyze on the language, what's going on here. Go from the beginning and say, wait a minute, was he allowed to do what he did? He's allowed, but that was an error. Why? Because the moment that he goes to the court and bring up international matters, he just expatriated himself out of his government. The moment they bring in another government constitutional law that he's not a citizen of that state, he's not protected under that law as a citizen because that's not his country. So therefore, somebody from the Department of International Affairs sort of went to the government structure of that government and sort of went there and said, hey, listen, this is the constitutional problem we got here. Your government courts convict the national. We gave you no authority if a dispute arises between the national. There's nothing in your law stating that that court got power to hear that matter. What you mean? The sovereign power of the government is between the legislative branches of the government. We never gave authority to have our citizens arrested. The moment he got arrested, there should have been word given to a council or a ambassador or a deputy based on international law. That was not done. What are you going to do about it? The council meets the International Affairs Department, and they iron it out. And what they do is they overturn the conviction and say that court did not have authority, was not delegated authority here, a matter pursuant to a foreign national of a treaty. And see, Shem, what is your proof, Shem? The Moor Sundry Act. When the Moors was sold in servitude, got took into servitude by African king and sold back to the colony territories, what they did? They did not go to courts for they recover lost sovereignty. They went to the legislative branch and reminded the legislative power that, hey, listen, your state is part of the United States. That central government that regulates international commerce signed a treaty with Emperor Morocco, a foreign prince. Therefore, based on that agreement, you cannot classify as being Negroes, black and colored people, and under your law. It doesn't apply. And the legislative power passed a legislative act, and legislative act override the courts. Which the Moor cannot be tried as a citizen of North Carolina, South Carolina. The Moor Sundry Act. That's the record. That's the record. Now, if a Moor get locked up in South Carolina, he don't need a council to bail him out. All you have to do is file what you call a writ and say, wait a minute, you do not have authority to trial me on the record, I declare who I am, my status, and go to that Moorish government and say, who steps behind him, a deputy, or whoever the international affairs is, say, listen, he's a Moor. It goes paperwork under your laws, based on treaty laws, law of the land. You declare in the legislative act that you don't have jurisdiction over Moor. That's the end of it. Period. That Quo Warranto will stop them from prosecuting him based on international law and based on state law. That makes what the treaty in the state of South Carolina, self-executed. A self-executed treaty based on a legislative act signing that, hey, you can't try more, you're not a part of our society. So we read something, go ahead.
Shem, let me say this though, Shem. This was brought up in 2019. You and I had this discussion in 2019, and that facilitated the drafting of you drafting which is in excerpts of that is in chapter 8 of Moors and Masonry part 2, addressing the assumption, the challenging was called just assumption that Moors are United States citizens and resident of
5 more
state.
minutes.
So, we talked about, it's in excerpts of that is in chapter 2 of Moors and Masonry. Chapter 8. Mute your phone, please. Mute your phone. And chapter 8 of Moors and Masonry, part 2, the Shem Malachi Beys were drafted in 2019. The assumption that Moors are challenging the assumption and presumption that Moors are citizens of the United States and residents of the state of the Union. All right. What I brought up to Shem in 2019. This was around. This was in the summer of 2019. This was a couple months after Shem and I began working together. And Shem had a particular document, and his issue was that he didn't want to put the European names that were forced on us on the Moorish document. And so I said, Shem, we would need to do that because our people have these, they're going to bring those issues up. They're going to bring the driver license, the birth certificate. And so we wrestled with that. Shem and I wrestled with that for a couple months in summer 2019. I let it sit for a couple months. I said, all right, I wasn't done with it, and I brought it back up to him in September of 2019. After sitting for, so Shem reconsidered that. He said, oh, you right, Abdullah? That Shem remembers. He said, yes, brother went to court and they had the birth certificate, they had the driver's license, they had the documents. He said, you're
Absolutely,
right.
yep, that's right.
And then so I said to Shem, yes, we need to get ahead of this. We need to, don't let them tell us, don't give them an opportunity to explain what those names are to us. All right. So Shem drafted in September 2019, which is excerpts, a large part of excerpts of that is in chapter 8 of Moors and Masonry part 2. The presumption and assumption, looking for it now, somebody can find it. All right. Presumption and assumption that Moors are citizens of the United States and residents of the state of the Union. I put a large part of that in chapter 8. I'm looking for it now. 223.
I remember that. We say they under the assumption and assumptions. That's the take. See, that's to take your heritage away, your national status, treaty protection away. By claiming that status, they are taking away your national status. And what they do, they're not denationalizing you. What they do is they expatriate you out of your what? Protection of your treaties. See, there's a difference between they can't steal your nationality from you because that's in your blood. That's consequently. But they can steal your political status. your status is claiming to be of that national consequentity. They can steal that from you. How they can steal that from you? By simply assuming, and making assumptions that because you got an English European name, you properly Europeans. That's not true. That's wrong. That's a faulty logic. That's not true. Because the language of a name does not put a person in servitude. A person in servitude is you stop them from exercising their right to say who they are. You can have a Spanish name and say, well, I got a Spanish name, but I'm not a Spaniard. I mean, my family don't come from this side of the world. That's not my domicile. They don't come from the ground here, earth, this part of the world. We come from another part of the world. So I got the name, a Spanish name, but that means I'm a Spaniard. So what they do is they expatriate you out of your. See, go back and read the Refugee Convention. There's a very good convention. Everybody needs to read that. The Refugee Convention, read that. Because what they're doing is they're expatriating you out of your government protection. That's why on the 59th Congress, it was asked a question between France and United States about Moorish nationality. What did the United States say? He that don't seek protection of his country is stripped of his what? His political status as a Moor. He's stripped.
And Shem, let me it's on page 49, page 249 of Moors, chapter 8 of Moors of Basic Part 2, page 249. This is post-millennium as the international law remedy for returning a people held against their will under the condition of slavery to their original condition before slavery. Excerpt of Shem Malachi Bey's proposed letter of termination of presumption and assumption that Moors are citizens of the United States and residents of the states in the Union. Letter of termination of all presumption and assumptions. I won't read all of it. Of citizenship of the United States of then birth state here. Place the United States of North America, United States and District of Columbia. The place of Moorish body politic here. Place Moorish body politic here. Consul, on behalf of the indigenous Moroccan Moorish national name herein, do now by transmission send this letter of termination of presumption and assumption. This letter of termination of all presumption and assumption that the state of birth state here, United States of North America, United States and District of Columbia, and any de facto newly incorporated state of birth state here, including all its executives, legislative, judiciary, authority, jurisdiction pursuant to the Audonashani or Audouania original beings, Lenape Moors, Moorish descendants of Moorish consanguinity that ascended to the Hague via post-millennium principle to protect our cultural property birthright by filing our Constitution, Charter Vessel Contract, and Proclamation with the United Nations under the Department of International Affairs pending number. Moorish body politic place here. Consular representing the X-Rail, the artificially created entity named Nam de Gear here by permission and consent of Moorish appellation here, the Attorney General, trustee, and fiduciary for the artificially created entity name Nam de Gear. Here, given by her father, after his or her birth, who are also of Moroccan Moorish consanguinity, and the Anuwanang original beings of this land of the Moorish Empire, of which their domination, authority, and habitation protracted from, known to the world today as North America, South America, Central America, including the adjoining islands known as Americana. The Moor named here in appellation place here, Moorish appellation here, has been held under the presumption and assumption by the state of birth state here and the United States of North America, United States, District of Columbia, and any de facto newly created state of birth state here including all its executives, legislative, and judiciary, including their departments, agencies, units, courts, foundations, inter alia, trusts that Namdegir here, and Moorish appellation here, and one and the same party, are one and the same party being listed and incorporated in the state of birthplace here, the United States of North America, United States United States and the District of Columbia, and any de facto newly created state of birth state here as a resident citizen. I'm gonna finish reading it. The departments, agencies, units, schools, and its public officials, agents, representatives, and officers for performing and representing the state of birthplace here and the United States of North America, United States, and District of Columbia, and any de facto newly incorporated state birthplace here, including all its executives, legislative, and judicial, including their departments, agencies, units, courts, foundations, and inter alia, trusts did not have a structured foundation, violation of international law. This is a violation of, this is a human rights violation. This is a human rights violation, all right, mass denationalization, did not have a structured foundation set up to rightfully and properly census, transmit the natural living being after birth of indigenous Moroccan Moorish consanguinity in their system of records to protect and safeguard the natural living being's nationality and birthright, power of political unity. The state of birth take place here has used the name that the mother and father put on the hospital registration form to be a resident of the state of birthplace here and a citizen of the United States of North America, United States, and the District of Columbia, and any de facto newly created state of birthplace here, including all executives, legislative, and judiciary, including their departments, agencies, units, courts, foundations, inter alia, trusts, without considering the mothers and fathers' Moorish consanguinity, mass denationalization, human rights violation, and being a part of the Moroccan Empire by nationality, consanguinity, national origin, descent, ancestry, genealogy, pedigree, parentage, and lineage, and an empire that signed treaties with the Kingdom of England, Great Britain, Kingdom of France, Kingdom of Spain, Kingdom of the Netherlands, Kingdom of Sweden, the Dutch Republic, Sardinia, Denmark, Belgium, and the de jure United States of America during the 1500s, 1600s, 1700s, 1800s. The indigenous Moroccan Moorish consanguinity, Moorish appellation here, is neither a natural living being of African descent nor Negro, colored, Black, and African American individual, party, citizen, resident, person. The application, then I wrote this. The application of the letter of presumption and assumption. Point one, diplomatic channels, Moorish consular representation and consular notification. All right, what we learned, what has been taught in this Moorish protection, Moorish treaty protection and consular relations series. I, Moorish consul here, a consul of the Moorish body politic here, declared that I take this deposition and the national Moorish appellation here in my presence, and said and speaks the sworn statement within this letter of restoration. Point two, Moorish consul raises the political fact that the Moor belongs to the Moroccan Empire by consanguinity, national origin, and descent, and therefore have a right to consular notification, consular representation, and Moorish treaty protection. Without, and this is an excerpt from the letter, all right, without considering the Moors without considering the mothers and fathers Moorish consanguinity and being a part of the Moroccan Empire by nationality, national origin, descent, ancestry, genealogy, pedigree, parentage, and lineage, an empire that signed treaties with the Kingdom of England, Great Britain, Kingdom of France, Kingdom of Spain, Kingdom of the Netherlands, Kingdom of Sweden, Dutch Republic, Sardinia, Denmark, Belgium, and the de jure United States of North America during the 1500s, 1600s, 1700s, and 1800s. Point 3, Moorish Consul, addressing the crime against humanity, issue of generational systematic mass denationalization. This is the excerpt from the letter. Did not have a structured foundation set up to rightfully and properly place in a census, transmit the natural lineal being after birth of the indigenous Moroccan Moorish consanguinity, and their system of records to protect and safeguard the natural living beings, nationality, and birthrights. All right, that's Moors and Masonry, part 2, chapter 8. I salute Shem Malachi Bey. I did wrestle with him with this. I wrestled, we wrestled, we wrestled, we wrestled, we
Yes, we
wrestled,
did. Yes, we did.
we wrestled. I let go for too much, brought it back.
You know what?
2019.
Abdullah, thank you for reminding me, Abdullah. You know, I forgot all about that petition we did. Now, me and Abdullah did that, right? This is the submit of this petition was to go before the council, the government body, the head of state of our government, and get them into a decree and grant it. Once they grant the decree and grant you asylum and amnesty, they send out an objection to the Attorney General of the state, United States. The Attorney General have a right to object on that claim that is made in that petition. But don't make a difference what they object to. The council can overrule that based on the evidence they find. So once the decree is issued, now the United States has been warned through an objection, and the objection be answered, it don't make a difference. That's a decree from the government, an amnesty. Now all the United States agencies have to respect that, because that's something coming from a foreign government protecting their nationals. So now when you go to use the name, now you protect it. See, the problem is we never know how to roll a name over. We think we got the name over. Oh, I'm a slave. No, you're not. No, you're not. You don't know how to use the name in commerce. You can use that name and still protect your consanguinity. That doesn't change your consanguinity. So that's very important. Yeah, I'm ready, Mom, right now. Hey, listen, I'll be right back on. Let me take care of this real fast. I'll be right back on. Go finish reading. We're going to prep. Right back on.
I'll continue reading, Amanda.
Okay, 1 complaint. A, whereas not one of the persons holding positions as judges within the jurisdiction of the courts of law within the defendant district court during times relevant have personally given, filed, and recorded a prerequisite penal bond or recognizance to lawfully acquire title to the public offices held, Section 10-2-9 NMSA 1978, since 1963, and which bound them to the promises in the oath of office contained in Article 20, Section 1, Constitution of the State of New Mexico, and as mandated by Article 22, Section 19, Constitution of the State of Mexico, as confirmed under provisions of Article 6, Clause 2 and 3, Constitution for the United States of America, to wit, respectively, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Clause 2, Article 6 of the Constitution for the United States of America. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. No religious test shall ever be required as a qualification to any office or public trust under the United States. Clause 3, Article 6, the Constitution for the United States of America. B, whereas the New Mexico legislature has no power or authority to unilaterally and without constitutional processes enact laws amending either the Constitution for the United States of America or the Constitution of the State of New Mexico without a referendum vote of the electorate for state amendments, as it did when, contrary to Marbury, it enacted Section 34-6-22, Personnel Oaths and Bonds in 1968, NMSA 1978, altering, revising, or amending Article 22, Section 19 of the Constitution of the State of New Mexico and Article 6, Clause 2 and 3 of the Constitution for the United States of America. To wit, said Section 34-6-2, before entering upon their duties, all district court personnel who receive or disperse money or have custody of property shall take the oath prescribed by the Constitution for state officers and file with the Secretary of State a corporate surety bond in an amount fixed by the Director of the Administrative Office of the Courts. Each bond shall be approved in writing on its face by the Director of the Administrative Office of the Courts, and conditions upon faithful performance of duties and payment of all monies received to the persons entitled to receive it. In lieu of individual bond coverage, the Director of the Administrative Office of the Courts may prescribe schedule or blanket bond coverage in any judicial district. Bond premiums shall be paid from funds appropriated to the district courts. C, whereas the several constitutional powers, each and every one of them cited in the preceding paragraph, are given effect in sections 10-2, -5, 6, 7, and 9 of NMSA 1978. D, whereas those persons during times relevant who previously held and those who currently hold positions as judges within the jurisdiction of the defendant district court from year 1963 and thereafter either did so or now do so under false pretenses as indicated below. 1, whereas any signed and notarized declaration of candidacy submitted for the record and filed among the records in the Office of New Mexico Secretary of State or the clerks San Juan and McKinley counties by any of those persons referenced above as lawfully holding positions as judges from year 1963 to the present, filed a falsified declaration of candidacy for retention or election, in that while holding a position as a judge, they, each and every one of them, did so unlawfully and thereby perjured the oath taken while only posing as an active judge by failing to support the above cited provisions of both constitutions, which became a fourth-degree felony as its inception and intentional when thereafter filed. See Section 1-8-40 NMSA 1978. Had there been a penal bond for those unlawfully holding public office, it could have been called by any citizen and the office immediately vacated, a constitutional power reserved to the New Mexico citizen. Section 23, Article 2, Constitution of the State of New Mexico. 2, whereas no judicial action to hear and determine this matter is authorized for the instant complaint until at least one district judge acquires a valid penal bond from a state authorized bonding agency or recognizance for an amount equal to an amount approved by the proper authority, which is thereafter approved by a judge of a superior court competent to act. Orozco versus Cox, 75, New Mexico, 431-435. Lopez versus Lemaster, 133 NM 5966. Johnson versus Cox, 72 NM 55. Cert denied, 375 US 855 1963, and which is filed for the record prior to entry to the office and acquiring title to the office sought and recorded among the records in the New Mexico office and Office of the Secretary of State in accord with 10-2-9 NMSA 1978. Now, therefore, neither the defendant district court nor a surrogate acting therefore possesses jurisdiction and thus competence to act for hearing and determining the instant case. 2, jurisdiction. A, constitutional claims. Without question, the district court has the authority to consider constitutional claims in the first instance. Masso versus State Taxation and Revenue Department, 2004-NMCA 025, 135 NM 152, 85 P3B 276, affirmed 2004-NMSC 028, 136 NM 161, 96 P3D 286. B, jurisdiction is acquired in criminal case by filing of information. State versus Vaughn, 74 NM 365, 393, P to D 711, 1964. Jurisdiction over state officers, boards, and commissions. Under this section and NM New Mexico Constitution, Article 6, Section 3, Supreme and District Courts each have original jurisdiction in quo warranto and mandamus against all state officers, boards, and commissions in all cases, whether the proceeding was instituted by the Attorney General ex officio in behalf of the state or for some prerogative purpose, or brought by some private person for the assertion of some private right. The Supreme Court will decline jurisdiction in absence of some controlling necessity, therefore, and will do so in all cases brought at instance of a private suitor. State ex rel. Owen versus Van Stone, 17 NM 41 121 P 611 1912. D. Section 44-3-4 NMSA 1978, to wit, 44-3-4, who may bring action, private relators, and when action lies, 1919. An action may be brought by the Attorney General or District Attorney in the name of the state upon his information or upon the complaint of any private person against the parties offending in the following cases. A, when any person shall usurp, intrude into, or unlawfully hold or exercise any public office, civil or military, or any franchise within this state, or any public office, or any office or offices in a corporation created by authority of this state. Or B, when any public officer, civil or military, shall have done or suffered an act which, by the provisions of law, shall work a forfeiture of his office. Or C, when any association or number of persons shall act within this state as a corporation without being duly incorporated, or in case of a foreign corporation, without being duly authorized to do business within this state. The district attorneys in their respective judicial districts shall exercise the same power and right given by this section to the Attorney General in cases which may be limited in their operation to the said district. When the Attorney General district attorney refuses to act, or when the office usurped pertains to a county, incorporated village, town, or city, a school district, such action may be brought in the name of the state by a private person on his own complaint. E, those persons holding public office as judges within the defendant district court have engaged in a course of libel and unfaithful conduct at all times relevant in the clear absence of competent jurisdiction, sections 10-2-5, 6, 7, and 9, and said Article 22, Section 19. Without judicial immunity, absolute or otherwise, Bradley versus Fisher, 13 Wall, 335, 351, cited in Stump versus Sparkman, 435 US 349, which is cited in Sias versus NM Judicial Standards Common Community. I don't know what that abbreviation is. 516 F sub 2D 1176 DNM 2009, and C State Ex Rel Evans versus Field. I don't know what that is again. Of Public Lands et al. 27 NM 384 390 for class of plaintiff's complaint, to wit, the other classes where a suit is brought against defendants who, claiming to act as officers of the state and under the color of any unconstitutional statute, commit acts of wrong and injury to the rights and property of the plaintiff acquired under a contract within the state. Such suit, whether brought to recover money or property in the hands of such defendants unlawfully taken by them in behalf of the state, or for compensation and damages, or in a proper case where the remedy at law is inadequate, for an injunction to prevent such wrong and injury, or for a mandamus in a like case to enforce upon the defendant the performance of a plain legal duty, purely ministerial and not within the meaning of the 11th Amendment, an action against the state. Citing cases. F, exercising jurisdiction where it is not given is a very serious matter. Chief Justice Marshall wrote in Cohen's versus Virginia, 6 Wheat 264 5L, Ed 257 821, that a court must take jurisdiction if it should. The judiciary cannot, as a legislature may, avoid a measure because it approaches the confines of the Constitution. We cannot pass it by because it is doubtful. With whatever doubts, with whatever difficulties a case may be attended, we must decide it if it be brought before us. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. Questions may occur which we would gladly avoid, but we cannot avoid them. At 404, emphasis added. Section 3, parties. A, plaintiff Kenneth Gomez is a free citizen of San Juan County, New Mexico, exercising power provided him by Article 2, Section 23, Constitution of the State of New Mexico, in conjunction with Section 44-3-4 NMSA 1978. B, defendant is the 11th Judicial District Court and for the County of San Juan and McKinley. Section 4, relief demanded under 42 U.S.C. Sections 1983, 1985, 1980, and 1994. 1, all defendant court judgments and decisions rendered since 1963 are to be voided. A, against Kenneth Gomez by the defendant district court and all subordinate courts of law within its jurisdiction. The attached list of cases, your own cases. B, against pro se litigants who are forbidden to practice law under state law while opposed by a party who is authorized to practice law, a practice with special privileges which denies and deprives a pro se litigant a substantive right to acquire legal prowess. Such judgments could not guarantee a fair and objective determination of the matter before the defendant district court because the practicing attorney gains legal prowess through practice under special privileges contrary to Article 4, Section 26, Constitution of the State of New Mexico, and Section 38-1-1, NMSA 1978, a special and substantive privilege unavailable to pro se litigants. Number 2, the court award the sum of $100,000 in cash money and at the time of a final judgment for each judgment and decision rendered against Kenneth Gomez in attached cases since year 1977. 3, that persons holding office as judge in courts of law within the jurisdiction of the defendant district court who have not acquired lawful title to the office held show what cause, if any, they may have, under what authority they qualify, hold, and possess title to the office, Section 10-2-9, without previously and personally giving, filing, and recording a penal bond binding them to the promises contained in their contract, oath of office, as mandated by Article 6, Clause 2 and 3 of the Constitution for the United States of America, and Article 22, Section 19 of the Constitution for the State of New Mexico. Memorandum brief in support of motion for a writ of Quo Warranto. 1, general background. 1, plaintiff Gomez on best belief alleges that there are no persons lawfully holding public office within the state of New Mexico. Those currently and who formerly held public office since 1963 within the jurisdiction of the defendant district court are members of that group. Moreover, among that group are those who have exercised the power of the judicial office under false pretenses to injure him. Accordingly, under provisions of Section 44-3-6, as modified by State Ex Rel. Anaya v. McBride, 88 NM 244-539, P2D 1006, 1975, plaintiff is authorized to require each of those currently holding public office as judges within the jurisdiction of the defendant district court to show in writing on what authority they hold office and give bond as required by said Section 44-3-6. 2, facts, points of law and authorities. 2, 44-3-6, usurpation of office, allegations and complaint, compensation of defendant, bond, injunction. 1919. Whenever such action shall be brought against a person for usurping an office, the Attorney General, District Attorney, or person complaining, in addition to the statement of the cause of action, shall also set forth in the complaint the name of the person rightfully entitled to the office with a statement of his right thereto, and in such cases, upon proof by affidavit that the defendant has received or is about to receive the fees and emoluments of the office by virtue of his usurpation thereof. The judge of the district court wherein such proceeding is pending, or a justice of the Supreme Court, if the proceeding is therein pending, may by order require the defendant to furnish a good and sufficient bond within a designated time not exceeding 15 days, executed and acknowledged as required by law. In the case of supersedeas bonds on appeal, to be approved by said judge, conditioned that in case the person alleged to be entitled to the office should prevail, the defendant will repay to him all fees and emoluments of the office received by him and by means of his usurpation thereof, and in addition to said bond, or in case of a failure to give said bond, the judge or justice shall, upon good cause, issue a writ of injunction directed to the proper disbursing officer, enjoining and restraining him from issuing to the defendant or his assigns any warrant, check, certificate, or certificates of indebtedness representing fees or emoluments of said office until the final adjudication of said cause. 3, Supreme Court would not give approval to portion of this section which requires the name of the person rightfully entitled to the office involved in a Quo Warranto proceeding to be set forth in the complaint, at least not if it is meant to affect the subject matter jurisdiction of the court, especially since the statute is inconsistent with Rule 12A and MR appellate AP Civ now see Rule 1-12A NMRA. Since any situation where a vacancy was filled by appointment under such reasoning, the court would be shorn of its constitutional powers vis-a-vis Quo Warranto, and presumably with additional bits of legislative ingenuity of its powers to issue other extraordinary writs as well. Such could not have been the intention of the people when New Mexico Constitution, Article 3, Section 1, and Article 6, Section 3 were adopted. State Ex Rel. Anaya versus McBride, 88 NM 244 539 P2D 1001 1975. 4, plaintiff joined with several other persons, searched the archives of the records maintained by the New Mexico Secretary of State for evidence that persons holding office within the state of New Mexico gave personal penal bonds or recognizance of a prerequisite to qualifying with title to the office held, and determined that no such bonds were given by any person holding state public office from 1963 to the present day. 3, argument, it shall be no difficulty for one holding public office lawfully to produce certified evidence of their qualification to hold title to their particular office. However, the challenge would be immediately settled should anyone holding office unlawfully not have evidence of giving and posting a personal penal bond or sufficient recognizance in lieu thereof on file and recorded for public viewing among the records on file within the office of the New Mexico Secretary of State. A liability bond under supervision by the Risk Management Division covering abuses of office is not sufficient to be considered as coverage for personal penal bonds, or Section 44-3-4 and 6 NMSA 1978 provides citizens the means to satisfy such a challenge. The archival records maintained by the New Mexico Secretary of State reveals that no penal bonds or personal recognizance given for any state public officer on file after 1963. Therefore, sufficient justification exists to require all those persons holding positions as judges within the defendant district court to show what authority they may have to possess title to the office held within a reasonable time allotted for that purpose. Conclusion, good cause exists for all those holding positions as judges within the jurisdiction of the defendant district court to provide formal certified evidence of their possessing lawful title to the office held. Kenneth Gomez.
I have a question, and respectfully, out of curiosity, is this complaint open for discussion or not at all?
No, it will be. I just don't know where Abdullah went. You won't be able to ask questions. I'm gonna call him really quick. He was calling Shem. He'll be right back. And then we can take questions.
I take some time to digest it. All right, me personally. Peace. This is Shem, by the way.
I'm back.
Peace, Shan.
Peace.
Peace. I mean,
Shem.
Yes. Any
Yeah,
questions on the document?
Yes, we did have a few questions.
Yes, go ahead.
Prince?
So I submitted a few questions into the chat. So I guess I'll start with my first question, going back to a statement, one of your previous comments, which is given what you said, which was that, and please correct me where I may have misinterpreted or misunderstood. If a non-identifying Moor is not familiar with the writs, the process for creating a writ and then also properly submitting or entering that writ onto the court's record, how would they be able to do so? How would they not need assistance or counsel?
Well, first of all, if you submit the writ on the court record, you submitting to the jurisdiction of the court. How's that? That means you're asking the court to do something for you. That means now you're pledging allegiance to that government because you want something from them. What I mean is that there's nothing in the Constitution or treaties that allow them to represent us or to go before them to get any remedies for any violations on our land. They out for doing business on our land. If we're in their country and we sign a treaty with them, best assured, they're not gonna let you judge them in their land based on your laws. They're not going to do that. That's not international law. No governments ever do that. They'll never let that happen. So what we
Okay.
got is, so if you file a writ, traditionally, the writ is supposed to be filed from the head of state, of that government, to the head of state and the other government. Say, what authority do y'all have? I mean, when did we ever give you authority or delegate authority to you or your court system, your preachers of the law to litigate, adjudicate on behalf of our nation, of our country, our citizens? So what happened now, it becomes void now because the government don't have authority to do that. It becomes void. So you got, it's a government-to-government relationship, not the courts. The courts do not have jurisdiction because they never had jurisdiction to hear the case from the first start. That's why they're not, that's why a lot of times dismiss it with prejudice or deny it. They're not being biased. They dismiss it because they don't have authority. That's the courts doing the proper thing. We dismiss it because we don't have jurisdiction.
Okay, so my follow-up question would be like in consideration that, again, my question was in regards to a non-self-identifying Moor. So someone who, you know, is not familiar with this, with the proposition or and concept of in the preservation of culture, more specifically towards legally standing on their square. And when that individual is, you know, accosted or detained and potentially, you know, wrongfully detained or incarcerated, aren't they being subjecting themselves to the Miranda rights that are read to them at the time of detainment?
Peace, Moore. This is Shem. This is your brother Shem. Shem, if I can chime in for a second, I think this is what we have. This is brother Shem. This is what we have these classes for. This is what government structure is for. And I'm not sure where you are and where you are in your concepts, but I know that one of the points that we've been hitting at home with for the past 2 or 3 months is being able to be in a position politically to reach out and grab our brothers and sisters who are not aware of their birthright and still bring them up under the protection of the Moroccan Empire and government structure. So based on what I've learned thus far, that is the purpose. We don't need necessarily all of our people to be awake for us to be able to move in that capacity, but we are brothers and sisters, we're moving in this capacity so that we can reach out and assist those brothers and sisters who don't have knowledge of their birthright just yet.
Right. But okay, so again, that illustrates and highlights, or more importantly, like emphasizes the point of my question, right? For those Moors who are unaware of their Moorish nationality and their identity, right? When they are detained and they're Mirandaized, and the recitation of the Miranda rights, it's anything that you say or do can and will be used against you. So if they're already subjecting and submitting themselves to a Miranda right, and they're already like verbally expressing that, you know, they're asking questions or whatever, wouldn't a simplified assumption, you know, and not to say assumption, but the simplified presumption be to address what it is that they're saying, or like create a solution particularly that
I understand what you're saying. Was you saying that somebody that's unconscious don't have the knowledge, and then in a bad situation, like I was in a bad situation, was though there is no structure set up, and a person got to have a remedy right there to protect themselves. I know exactly what you're saying. Let me say this right here. When you face with a situation when a car is coming, right, even though you don't have a barrier to stop the brakes of the car from hitting your bus, automatically it's your common sense to get out the way. So as you talk about a man don't have protection, he's stepping away or something. He got to make a fast, harsher decision. So based on what he got in front of him, he have to use that. I got you. I know what you're saying. I would say this right. When me and Abdullah talked about this in 2019, he right. We wrestled with the same question. And my thing was, we came up with what you call a petition. Now, I started coming out, I said, you know what, Abdullah, the problem is we have not among ourselves come together as a group or anybody to do anything to address these matters. That's the main thing him and I knew. That nobody ever addressed these difficult matters. And by me being in that situation, being locked up before in conquest like that, colonial powers, I can understand what you're talking about. Now, I will say this right here. Anybody that got locked up and get stopped by a cop, the best thing you can do, the first thing you do is shut your mouth. Don't say nothing. Just say, somebody say, well, I'm shook my Second Amendment right to be quiet. You can just, I'm not talking to you. And
Fifth.
see, now watch this. How do most Moors get in conflict with, in confrontation with the police? To a vehicle, right?
Well, it's usually while in a vehicle, but there are other factors that we would probably have to like address in that scenario.
Children that come in your house, they come to your house. You live. See, we understand everything you do is done under political jurisdiction control of the United States. If you buy a house, you're a grantee. The United States is not the owner of the land. They're leasing the land, leases. They assign a lease over to you to operate an erection, which is the shelf that's connected to the land, a Moorish land. Therefore, they got political jurisdiction in their house, over their house, direction. You live in that direction, you're not protected, and that's the law because you never state, there's no government protection protecting you. So what you have to do is say, you get stopped. Okay, let me force the refugee convention. What's the refugee convention? I'm in a foreign land, hostile on a conquest. I got a right to be protected by the laws of that government. Now, when somebody says, okay, what are you going to do? Okay, when somebody is trying to serve authority, if you go to court and say I'm a Moor, they're not going to litigate that. They don't have jurisdiction. That's why the case is dismissed. But if we go to the courts and say, in your proper person as what? As a person standing in law, as a person, you're natural flesh and blood. So you say, well, you don't have authority to do what you're doing based on what? There's no delegation authority given to you by your government to allow you to step in this capacity and do what you're doing. So you will have to file a Quo Warranto in a civil court.
But I think what you're also expressing is, is one, I think you're also expressing like 2 points, right? What someone might think about doing reactively, looking back in hindsight, right? But ultimately, like what we're looking to essentially, what I think I'm hearing is, how do we create a solution for when a person who doesn't know about their nationality, does not know about their culture, opens their mouth and makes the statement towards any kind of previous agreement that they may have had, because they're already acknowledging, a certain level of jurisdiction that they've permitted over themselves by accepting the Miranda rights, right?
No, you don't accept them. You just when they read them to you, they only read to you how far the guideline policy, court
but
policy.
we're talking about, respectfully, and I apologize about interrupting, right? As adults, if someone says anything that can and will be used against you in a court of law is uttered to you, right? And you still make a verbal statement, that's you acknowledging and also waiving your rights. So so what's the reactive solution to that?
Well, the first thing is you under duress, and the division, duress, and coerce. What you mean? That means at the time in the atmosphere that I'm in, I feel threatened. If I don't do what they say do, something gonna happen to me. In other words, see, most people talk because they think that they're gonna be let go out of jail, out of custody, out of detainment. They're gonna stop detaining them. That's why most people start talking. They think that if I talk, they're gonna not detain me. No, they're not. No, it's called duress, and duress. The rest is considered a mental threat, which a person feels that they're in threat of their freedom and liberty. If they don't say something, they're not gonna be let go. They're gonna be blamed for a lot of stuff, a lot of charges. So they better start talking so they try to get their way out of the situation they're in. So that's a mental vice. So even though they read it, you say it, you're gonna think about it. If you read it, they say it doesn't make a difference. You still don't have jurisdiction on me. You still deal with jurisdiction. What gives you a jurisdiction on me?
But it comes back to government structure, and so needing the Moorish national government structure to be able to.
Yes, I agree with that. What he's saying is that a situation now where right now, if I walk up my house and I run into a cop, that's a problem. We don't have what you call a stabilized national government that's acknowledge themselves, the resume of all the nations of the world that we are standing people, something among ourselves. We don't have that right now. So right now he's saying what they start reading my Miranda rights right away. I start talking. The moment they step over with guns and stuff and surround me, automatically I'm putting a hostile situation. I mean, I'm threatened right there. And most people are threatened to say, listen, if I don't say something, they're gonna hold me and give me all these charges. I don't feel like getting held. So
Okay.
under the declination that if I say something, they're gonna let me go. Most people think that cops, if they talk to cops, they're gonna let them go. They're gonna stop arresting them. They're under that mindset. That's a metaphor, a metaphysics of people thinking, oh man, ideology. If I don't talk to them, they're gonna lie on me and lock me up and blame stuff on me. No, it's not. That's a mindset. That's mental.
Mhm.
So what he's saying is what we're gonna do now if they mess with us. We know that right now we need to establish a national Moorish government that we can address these issues. But right now, the only way you can address it is you got to force the de facto laws that they have to protect yourself under that status.
Okay.
Once they detain you, you are captured. Please hear me out.
Mhm.
You first of all, here you go going down the street without a passport or ID, a sign. That's your passport. The passport for your body, the passport passes borders. They travel on your own land. You don't have a national ID, you got a state ID. Automatically, you got a state ID to them, you under their jurisdiction. You identified by them as being what? That's a presumption. See, once again, we're back to this. Professor Abdul addressed this back in 2019 about the assumption. Yes.
Hey, Shem.
Yes.
Hold on, I gotta stop you because we got 6 minutes. We got 5 minutes. We got somebody's hand up, so we gotta stop that. We got 5 minutes.
I'm on, Abdul. I'm on all the way through, Abdul. I'm on. So let me go.
Shem. Makakuvu will be on in 5 minutes.
Okay, I'm sorry. Go ahead. I'm sorry. Yes.
Shem, you have 5 minutes. We have a hand up.
Okay, go ahead.
Let's address this owner, the owner. We acknowledge you. We got 4.5 minutes.
Okay. Next hand.
Oh, this is Brother King El Bey. I just want to shed some light on that. You got to remember this is contract law. So when we're dealing with contract law, the first thing you must understand in relationship to what's going on, you always have to object. And you have to understand what is the very thing that is the deal breaker in every relationship with the United States, and that's due process. If you don't know about informed consent and informed notice, the thresholds that's necessary to make it contractually binding contract, then what will happen is you will be acquiescence. So if you need to look up case law and study case law on due process violations. When there's a due process violation, that is the deal breaker. The courts say anything that violates due process under certain elements is the deal breaker. So when you go into a court, the first thing you're supposed to do is give notice. You object to the proceedings. We talking about preserving your rights. And then you got to disqualify it on the grounds of informed consent. Uninformed is violation of informed consent, violation of informed. Once you disrupt that due process issue, the case is over.
Let me say something on this. See, this is what we call a slippery slope. See, nobody wants to address the true fact of it. I'm speaking from experience. I had a brother, Abdullah met this brother, spent 9 years in jail with that contract law. See, this is what I keep telling people. When it comes down right now to where it's so wicked and they were so about the money, when I did the thing, challenging the jurisdiction and stuff, the first thing happened, they trying to declare me incompetent and crazy so they can remove me to a mental institution and around. See, I speak from experience. I spent 24 months because I
You
would not
got
take an
2 minutes.
attorney.
You got
I
2
spent-
minutes. You
Yeah,
got
I
2
spent-
minutes.
I spent 24 months incarcerated because I would not take an attorney. That's number one. The second time was in North Carolina. I got locked up in Hicktown, North Carolina, in Hicktown, Ku Klux Klan land called Ku Klux Klan land. And one other time I got locked up. What I'm saying is that it's a slippery slope. When you're operating without a government, you're under protection of your country, you're on a slippery slope. What that mean? They already got the deck stacked. When you come in and say, okay, you paying as a proper person. Number one, they're against you. You know why? Because you and their court was set up as a stock exchange, contract law, commodities. You're not a dealer. Attorneys are lawful dealers, licensed by the state to represent what? The sureties, the property. You property of the state, you goods. So when you go to courtroom speaking, automatically that's a violation to them because you ain't allowed to speak. Because the corporation set up to be run by what? They're all licensed dealers with attorneys at law. Yes, that's how it is. That's why when you go to courtroom, you argue due process. The judge sometimes sit right there. A lot of times they sit right there and wait and say, okay, pass the case, don't take it back to jail. You go back to court again. Somebody say, well, they won't bring me in. They move everybody out the courtroom and then they hold the case. But here's the thing about it. When you do it that way, even if you win, who progress off of that? Not your sister, not your brother. You only progress is you walk away one day, making a stand one day, and go right back outside the courtroom and go back in the next day, locked up. And then this time you're crazy. So when you run into these people, it's a bad. I'm gonna tell you, it's a slippery slope. That's why it's very important to have national protection. It's very important because it's a slippery slope. And so what we need to do is make decisions when we're doing business in the state of the amity flag, the maritime flag. Maritime amity, they operate with maritime contract. What's a maritime contract? Amity contract, they will have goods in the high sea off ships, amity, ships. The country's a ship floating on a vessel. The land is floating like a ship on land in the water. You living on a ship like a vessel. You have cargo on the ship. So when you go into the courtroom, you're not going there as a Moor, you're going as a cargo, shipment, goods. And the attorney's the only one can represent them goods. So you gonna start coming in as what? As making a special appearance, speaking for myself. To them, you supposed to be dead. You don't exist. They can't talk to a dead person. You dead. Matter of fact, I'm gonna teach you. You never made the birth. Because the day you born, they say you 1 day old. How you gonna be your mother's birth stomach maturing for 8-7 months and you come to get born, you 1 day old? It's impossible. You can't be. You 8 months, 2 weeks, and 5 days old. You're alive. You're alive in your mother's belly. So the day you come out, they say you 1 day old. You dead. That means you artificial. You don't exist. What should be 1 day? That means the first day they created an artificial being, and that's all they're dealing with. Artificial being, a dead person. So you go to court and say, "I'm paying my proper person." You say the dead man woke now. It's resurrected. That's a problem to them now. That's like having a dog or a pig or a cow start talking. You cattle. You ain't supposed to be talking. That's like having a funeral man just bomb the body and have a funeral and the body start talking. You ain't supposed to be talking. You're supposed to be dead. So I mean, now everybody's in trouble now. You talking? You say the license policy insurance company, the undertaker, everybody's dead. It's high doctor because they declare you dead. Now you talking. You're talking now. You ain't supposed to be talking. You dead. So you go to the courtroom, the deck is stacked against you automatically. You can argue due process. This is what I learned. What I learned this right here, because I'm gonna tell you, man. Another time, I'm gonna stop because you got
I'm
5.
in. You see me?
Yes.
All right.
I'm gonna go ahead and stop because you got 3 more minutes after 2 more minutes?
No, we ready. We in. That's it.
Okay.
Is
Let me
that
get back
you,
to that.
Makakuvu? All right. Thank y'all. All right. So we have Makakuvu Ali El Bey. Makakuvu Ali El Bey, Ateker Kingdom Alliance. All right. You'll be speaking for the next hour. Do you have a guest with you, Brother Makakuvu?
The ambassador is supposed to be coming in. Let me see. I just got off the phone with him.
I think I'm here. This is
Yeah, you here.
Ambassador Prong Kajulo.
All right. All right, welcome to the Moroccan Post School for Government and International Law. Welcome. Thank you for joining us. You will have the floor for the next hour to make the presentation, and we'll also to field questions. Thank you again. All right, Makakuvu, I'll turn the floor over to you.
Due in the chair, Uduma Akuyua. Thank you. Thank you, Your Excellency, and welcome, Your Excellency, Ambassador Oprong of the Ateker Kingdom Alliance and the Ateker Kingdom Alliance, LLC. I'm going to briefly introduce myself, and then I'm going to yield to Ambassador Oprong so he can introduce himself. And then I'll pick it back up when he's finished introducing himself. And then I will, from there, give a brief on the Ateker Kingdom Alliance and allow the ambassador to give some background, and then I'll take it back over. Makakuvu Ali El Bey. Makakuvu is my spiritual name. It was revealed to me almost 60 years ago when the tongue, Uduma Akuyua, was given to me for our people. And I'm gonna say that again.
Excuse me, Makakuvu, you wanna put your video on? Is that?
Let me see, how do I start a video?
Video is on. It's on.
His video's on, I don't see him.
I see him moving around. But
I
Joe,
see him. I apologize. You're on.
Joe, if you want to stop sharing your screen, then we can see him. Sorry.
We're good. Thank you. Thank you. I see you, Makakuvu. I apologize. All right, I see you now. All right.
Yeah,
continue.
I got the Queen's coat of arms on behind me.
Thank you.
So again, my spiritual name was revealed to me by the Nachir. So when you hear me say Nachir or doing Nachir, that simply means the Most High, or what some people call God. I don't use that term God. I use the ancient tongue, the Medu Neter, the Nachir. So when you hear me say doing the chair, all I'm saying is thank God or praise the Most High. Uduma Akuyua is a tongue, it's not a word. It was given to me for our people. Uduma Akuyua, the vibratory frequency, means lion of the new dawn, and this is very significant. Lion of the new dawn. So when I say lion of the new dawn, you automatically think about a lion. And you think about the sunrise. But when I say Uduma Akuyua, lion of the new dawn, the lion is our consciousness. So instead of visualizing a lion, think about the mind of our people. Because the lion is our consciousness. The new dawn is the resurrection of our consciousness. So now you have a different perspective. Now you have the perspective of Uduma Akuyua being the vibratory frequency to wake up sleeping Black folks. Sleeping Black folks, or as you say, unconscious Moors. So now, go back to the lion. And here's the question. What happens when you wake up a sleeping lion? Think about that now. A lion sleeping and you wake that lion up. What happens next? I'm gonna tell you. You get eaten. Now, relate that analogy to the waking up of the dead mind of our people. So Uduma Akuyua, the vibratory frequency of spiritual liberation, is the vibratory frequency that regardless of whether they want to wake up or not, they're gonna wake up. Because it's coming from the heavens, it's coming from the cosmos with a K, not a C. So my first foray directly dealing with Alkebulan and the de facto European states that make up the so-called African Union, because that's what they are. They're de facto European states. The currency, the economy, the political system, the military, all of that is backed and financed by European states. So they're not countries. Those boundaries are delineated by the European Conference in 1888, the Berlin Conference under King Leopold. And you all know that. I began through a colleague of mine working with the campaign for New York City public advocate, the brother Sadiq Y, who is currently the Sierra Leone ambassador to the United States. At that time, Sadiq Y was the highest ranking civilian in the New York City Police Department, reporting directly to Kelly and then Bratton. Sadiq was running for the position of public advocate against Tish James, who was the current New York State Attorney General. I was working in this campaign, and I've known Tish James for about 30 years already. In any event, I met a brother there named Fale Balde from the Gambia. And Fale asked me to begin working with him after Sadiq lost the campaign to Tish James, and she became public advocate. Fale Balde asked me to work with him with the West African Development Society. And we did some things and did a couple of fundraisers, and they were on my television channel. I'm the Legacy Builders CEO for the World Media Coalition Jazz Lovers Television Network, WMCJL-TV. So Fale asked me to work with him with the West African Development Society. And then he said to me that they were also working on promoting the candidacy of Adama Barrow, who I met before he went back to the Gambia. And they were supporting his candidacy for the presidency of the Gambia. In the meantime, the Gambia was ruled by a dictator for 22 years, Yahya Jammeh. He walked around with a Quran in his hand like he was such a holy person, but he was a brutal dictator. He raped, he tortured, he robbed the land, and he killed people. Every other year during his 22-year dictatorship, there was a coup attempt, and every one of them failed. The last coup attempt was in 2014. In December, some people stormed the palace, some expatriates from the United States and other parts of the world stormed the palace. Some got killed, some escaped and came back to the United States, the ones who were living here, and got arrested by the FBI in Houston, Texas, for trying to overthrow a foreign government. When Obama was elected, he invited Yahya Jammeh to meet with him during the General Assembly week. And they had a protest. Fale Balde and some other expatriates had a protest at the United Nations. And the ambassador to the consulate, the permanent mission of the Gambia to the United Nations, Ambassador Mamadou Tangara, spit on Fale. Fale hit him and knocked him down, and the police came and they were going to arrest Fale. And Fale said, well, if you arrest me, you got to arrest him because he spit on me. So they left it alone. After that last coup attempt, Fale came and said, listen, we're going to try a new approach. We're going to write a letter to Yahya Jammeh to ask him to engage in high-level talks for free and fair elections to remove him from office. When Yahya Jammeh authorized the ambassador, Sheikh Fahd, from the embassy in Washington, D.C., Fale said to me, he said, Makakuvu, we want you to lead the talks. So I led the talks and I produced the only television documentary of those high-level talks, the first high-level talks at the masjid in the Bronx, over 150 people in the room, with the ambassador sitting at the table and his protocol officer, Pierre Menta, at the table. Fale Ballet was there. I led those talks. You can see that documentary on YouTube and on my channel. It's called The Gambia, the Flower of the African Conscious. The Gambia, the Flower of the African Conscious. Those talks achieved something that had never been done. Jesus, Muhammad, Moses, none of them ever accomplished what those talks accomplished, which was the removal of a brutal dictator without civil strife, violence, or civil war. There was no bloodshed. There was no bloodshed. That is my brief introduction of who I am. I'm gonna yield to Ambassador Opong right now. When he finishes speaking, I'm gonna take the back and I'm gonna expand on what I just told you. Your Excellency, please, I yield to you.
Thank you, Your Excellency Makakuvu. Thank you, Joe, for having me here. I don't have much today. I feel honored and grateful that I'm part and parcel of this initiative and this movement. And I come from the Ateker Kingdom, as Honorable Makakuvu has said. I represent the Ateker Kingdom, which is a group of over 750 kingdoms from Africa who have come together to unite and be like one vehicle that is going to unite all of us, the diasporas and our brothers from Africa. So I'm very privileged and happy that I have been introduced to another group of my brothers and sisters that we will harmonize and team together to work towards our one common goal. So for today, I will be listening. I want to know more, and then as time goes by, then we will engage ourselves in many aspects and discuss more. So thank you, Honorable Makakuvu, for bringing me and introducing me to the group. I really appreciate. Thank you. I yield back the floor to you.
Thank you, Excellency. Thank you very much. The reason why this introduction is so important is because as Mori Amazi, and I got to take this back a little bit because people know the so-called ancient civilization of Atlantis. And Atlantis, so-called Atlantis, I got to say so-called Atlantis because when you read the histories of Herodotus, who was supposed to be the father of history, who visited where Atlantis is located, which is the Eye of Africa, which is in Mauritania. The exact archaeological dimensions mentioned in the book written by Herodotus have been discovered in Mauritania, which is called the Eye of Africa. And in that location, and in the book, The Histories, Herodotus states specifically that the people of the Atlantis called themselves Maori. So if the people of Atlantis called themselves Maori, and historically people named themselves after the land, then the land must not have been called Atlantis, because if it was to call Atlantis by them, they would have called themselves Atlanteans. They called themselves Maori. And the reason why the Ateker Kingdom Alliance is so significant, because from the roots of the Ateker Kingdom, the Ateker people, the Ateker tongue, comes from the depth of the ancient Hapi, Nile Valley civilizations, going back 15, 20, 30,000 years. So they're Moors, as are we. So now what you just heard Ambassador Oprong said is that not from the false delineations of the so-called boundaries of the 54 countries, with the exception of Ethiopia, which was never colonized due to the royal house of Menelik and the royal house of King Solomon and the royal house of Makeda, Queen of Sheba. The other countries were delineated by the Berlin Conference of 1884-85. So they're de facto European states. And what Ambassador Oprong has said is that the 750 kingdoms, which is an entirely new political body politic that's emerging on the continent, they're welcoming us home to build a platform of not just physical unification, economic unification, but more importantly, spiritual unification. So now, in 2017, May of 2017, I hosted my first economic development summit, Harnessing the Diaspora Economic Current, Economic Development Summit. And I'm gonna say that again because there's a specific message in that title. Harnessing the Diaspora Economic Current. Ain't got nothing to do with money. Nothing to do with money. What it has to do with, in the simplest form, is the energy seated around the table right now with us. The spiritual consciousness seated around the table right now with us. The capability seated around the table right now with us. So harnessing that energy to invest it in an activity that lifts us is the economic currency that we're talking about, which will yield dollars and cents and gold and tokenized currency and fiat dollars. So in 2017, I hosted the first one, Harnessing the Diaspora Economic Current, Economic Development Summit, with my colleague, Fale Balde from the Gambia, at the headquarters of the African Union, 2017, May of 2017. In September of 2018, I hosted the second one at the UNESCO Associate Headquarters during General Assembly Week, across from, like I said, the United Nations at the UNESCO Association Headquarters, and the headquarters of the United States-China Thai NGO, the United States-China Thailand NGO headquarters. The third one was in 2019 in Queens at Thomasina's, and that was the smallest one. The fourth one was this past October here in Atlanta, and that one resulted in this company, Tough Built Tractor, bringing the tractor to that summit from Nebraska. They towed the tractor with a pickup truck and a trailer behind it with the tractor on it to Atlanta to showcase their tractor so that the Ateker Kingdom Alliance would be able to see the results of my efforts, our efforts, and now they are positioning themselves to buy the tractor company. And Ambassador Oplong can attest to that. How did I get involved with the Ateker Kingdom Alliance? It's been over a year. The Ateker Kingdom Alliance was part of the royalty that came from the continent on the Tears of Love pilgrimage to the Americas that was originally scheduled to come to St. Louis, Missouri in August of last year. And because they got jerked around by the people in Missouri, they decided to come to Atlanta. I was contacted by Princess Sheppy in South Africa, Her Royal Highness. When she brought that information to me, I made some phone calls back to her to find out who was the point person on that. She gave me some information, and we were able to facilitate a series of WhatsApp calls and Zoom calls. And that's when I met Ambassador Oplong, His Excellency, for the first time. And in those discussions, which were ongoing, it just didn't happen one time. So from April ongoing, in those discussions, Ambassador Oplong said he was in the United States. I asked him where. He said in Springfield, Massachusetts. And I said to him, well, I got to be in Boston in July of last year for the Wet Within Pet, the Comedic New Year celebration. And I asked him, would he meet me there? And he did. I got all this documented. Everything I'm telling you, I got documentation. I do television. Everything I tell you, you can find it. You can see it on my channel. So in any event, moving forward from July, I had, well, before even then, they had asked me to get in touch with the Numai Theocratic Indigenous Moorish Kingdom sovereign Muabdi. I can't call him King Muabdi because he turned out to be a snake. So I will just tell you straight up and down what the situation is and how I got to be where I am with the indigenous kingdoms from Alkebulan. So I brought this to Numai Kingdom. I had rolled with Numai Kingdom. You notice I said from 2019 to 2022, I said nothing about doing an economic development summit. And that wasn't because of the pandemic either. What the pandemic did do, during the conversation that I was able to lead the talks to put Adama Barrow in his first term in office, he's serving his second term now. We were moving forward to bring a delegation from the Gambia, and when Mamadou Tangara, he went from the consulate in New York to the Gambia, and became the Minister of Foreign Affairs. When he wrote the letter to the embassy in Banjul, the US embassy in Banjul, for the visa applications and appointment, the next day after they got that letter from Tangara, they shut the world down because of the pandemic. So we lost a $300,000 contract to host that delegation to come over here. So in any event, prior to meeting Ambassador Oplong, we're moving forward to unite the Kingdom of Numai with the delegation for the Tears of Love pilgrimage to come over. And I immediately got in touch with Princess Sheppy in South Africa, and she put me in touch with Ambassador Samson Isudu in Guyana. And we had our talks. I got in touch with some other people who were recommended to me, Professor Gershon Williams in April of last year and asked them to come on our television production. His Excellency Abdullah Bey has been on several of my television productions. Tomorrow, he's coming on, and you are invited as well to come on, all of you, because we have the Honorable Hammurabi Bey speaking on tomorrow at noon. And for those of you who know Hammurabi Bey, you know he's the father of Dougie Fresh, the hip hop artist. This is the second time he'll be on my production. He's on my production with his other son, Abdullah Bey, and his grandson, Imhotep, from 10, 11 years ago. He's coming on tomorrow, Hammurabi Bey, because we're bringing the Moors, we're bringing the Mori Amazi to the Ateker Kingdom Alliance. And if I'm correct, Brother Abdullah Bey, he read the letter of appointment. Did you not read it, brother?
Yes, we read it. We read it 2 weeks ago and we read it tonight. Yes.
Okay.
Yes. We read it 2 weeks ago. We read it tonight. Yes.
Excellent. Excellent. So tomorrow he's got Brother Bey's got the link. Abdullah Bey's got the link for the Telegram production. You're welcome to come in. And you come in, there is always a consistent procedure that we do. We always open up the floor for people to participate in the discussion. So in any event, I brought this to Muabdi, and I'm also part of the Atlanta Juneteenth celebration because I led their first parade 9 years ago, and I've been involved with Atlanta Juneteenth ever since then, and it's the largest Juneteenth celebration in the country. So I said to Muabdi, I said, I spoke with the brother who runs Atlanta Juneteenth, Bob Johnson. I told him about Numa Kingdom. He said, Makakuvu, I need to have the king in the parade. So I took that to Muabdi. He refused to go. I rode with Muabdi for 4 years, from 2019 to 2022. Okay? I rode with him. We never did a summit. I said to him every year, we need to do a Moorish summit. Oh, Makakuvu, the Moors ain't together. I said, that don't mean nothing, brother. They know who I am. I've already done several nationality and governance conferences with Nakeem Bey, Hakeem Bey, Taj Tariq, Pleasant Bey before he turned his name into Akhenaten Bey. They know who I am. So we need to do a summit. Makakuvu, we're not gonna do that. So he didn't do it. I bring him to Numa, to the Ateker Kingdom Alliance. They were initially going to St. Louis. The people in St. Louis jerked them around and cut their money. We're having conversations. They decide they want to come to Atlanta. When I first met them, I said to Gershon Williams, in April, I want to bring you on the television production, introduce you to Muabdi. Oh yeah, okay, bro, that's a good idea. The 15 minutes before we go on the production, he calls me, he's not gonna come on. I said, no problem. I did the trailer and everything. We ready to roll. He didn't come on. I still did the show. It's on my channel. I'm gonna send the channel to Abdullah Bey. He's got it already, but I'm gonna send it again so he can send it out to you. And I want you to subscribe to it and like the productions because we need to build our viewership. I got stuff on my channel that goes back. We got the Gambia, the Flower of the African Conscience. We got a lot of stuff. You put my name on YouTube. Don't even have to put my last name. Just put in Makakuvu. I'm the only Makakuvu on the planet. It comes up. So in any event, Muabdi don't want to do the Juneteenth celebration. They had over 60,000 people come in 3 days, but he don't want to go. We was going to showcase him in the parade. He don't want to go. Gershon Williams canceled the production in April of last year. Don't call me back. Now all of a sudden, I say to Muabdi, they want to go to St. Louis. I say, well, listen, we need to do an event prior to August when the delegation gets here. No, prior to going to St. Louis, we need to do an event so we can raise some money to go to St. Louis. They don't want to do that. He tells me, well, set it up with his queen. So I start talking with her, and they turn around and sabotage it. And then they have a meeting 2 weeks later, talk about who wants to go to St. Louis. We had 18, 19 people on that call. But when I was trying to work with the queen to do an event to make some money to send to people to St. Louis, ain't nobody want to get involved. But now everybody want to go. So I said that. They got mad at me. I said, I don't care. I'm not lying. You got all these people on the call right now, but don't nobody want to work to help make no money so we can send people so they don't have to go into their pocket. So now they switched it up. They want to come to Atlanta because the St. Louis people jerked them around. I'm the one that brought them all together. So now I'm still in the conversation. Muabdi turns around and he puts somebody that lives in Houston, Texas, to help organize what they're going to do when they get down here. I said, man, you should have put somebody on the ground here that knows the territory here. The woman ain't never been to Atlanta. How are you going to set her up to organize the stuff here? And I wasn't talking about me doing it. He didn't like me saying that. You see, the problem that people have with Makakuvu Ali El Bey is because I speak my mind. I don't bite my tongue. I speak what I'm thinking, because if I don't speak what I'm thinking, you'll never know what I'm thinking, and we'll never get to a point where we can get something done. Because the object is to get the goals accomplished. So now, they decide they want to kick me out. They want to kick me out. They don't want me involved, but I brought all y'all together, but you don't want me involved now. So they kicked me out. They kicked me out, and I was gone. Ambassador Oprong, His Excellency, and Ambassador Opalak in Uganda, they maintained communication with me, although they knew that all the way from the top down, they kicked me out. And I'm gonna explain that in a few minutes, because I'm talking about how I got involved with the Ateker Kingdom Alliance. I've been involved for over a year already. Over a year already. I'm the one that brought everybody together. And when they kicked me out, due to His Excellency Ambassador Oprong, who met me face to face. Now, none of them other people, with the exception of Muabdi, the Numa Kingdom, had ever met me face to face. Ambassador Oprong met me in Boston, watched me deal with the weapon pet. I was one of the main people at the weapon pet. I got the video. Up in Boston, we're doing another weapon pet in Boston this year. I'm already in talks with Patar Osar up in Boston, Massachusetts, because he's going to be part of the convention. We're bringing everybody together. I'm a Kemetic high priest. I'm the official high priest for the Universal Zulu Nation. Last November, during the Hip Hop History Month, during the anniversary of hip hop and the Zulu Nation anniversary, I initiated the 5 elements of hip hop: knowledge, humanitarian knowledge, global ambassador awards, and instituted the Ambassador Corps. And I drafted ambassadors from around the world as hip hop, humanitarian knowledge, hip hop global ambassadors. Yeah. And that's another story. I'll tell you how that came about another time. So I have the authority from the royal ambassador, from the hip hop ambassador, from the World Humanitarian Organization for Peace and Equity coming out of Nigeria. I have the authority to appoint ambassadors. As a high priest, a Kemetic high priest under the Het Nachir Shishini Hech Ha-Nub, Kera Amin-Ra, Temple of the White and Gold Lotus, Shrine to Amin-Ra, and the Het Nachir Udama Akayua, Kera Amin-Ra, which is my Het Nachir, my temple, the temple of the Lion of the New Dawn, Shrine to Amin-Ra. I have the authority, not from no white man, not from no fictitious entity, but from the entity of the Nachir being placed in these positions. That's why you could have heard that letter that I signed off on and Ambassador Oprong, His Excellency, agreed on. Ambassador Abdul Labey. That's why you can hear that letter like that. So now they're coming to Atlanta. They kicked me out. His Royal Highness Papa Sunday and several kings and queens and princes and princesses come to Atlanta. I got the pictures, they sent them to me. I got the pictures. I got everything that I'm telling you in my phone. There's nothing that I'm telling you that cannot be substantiated, validated, and represented properly. That's a lie. Everything is provable. So now they get to Atlanta, I don't go. I get a phone call from Ambassador Oprong. His Excellency called me and said, Makakuvu, I just got off the phone with Papa Sunday, and he wants to have a meeting with you in his hotel room. Is that what you told me, Your Excellency?
Yes, that's what I told you, sir.
So then, in the meantime, I'm still communicating with Ambassador Opalak, and Ambassador Oprong and His Excellency Ambassador Opalak are communicating between Uganda and the United States, talking about me, communicating with His Excellency, His Royal Highness Papa Sunday. And Papa Sunday says, okay, I'll meet with him in my hotel room that Sunday. So I go to the hotel room. I do not go to the event. I go to the hotel room. To the hotel room. Now, Bob Johnson and the people with the Juneteenth celebration, I had introduced Bob Johnson to Muabdid when I was coming back from Boston because they were scrambling to try to get some sponsors. So I said, well, let me introduce you to Bob Johnson. Since you didn't go to the Juneteenth celebration when you could have met and represented yourself to over 60,000 people, you didn't want to go, but I'm still going to treat you like a brother. And I'm going to introduce you to the brother. So I put Bob Johnson on the phone coming back from Boston. We driving, coming back from Boston. And I put the brother on the phone with Muabdid. And right away, Muabdid wants to make him an ambassador right away. Didn't vet the brother, nothing, because Muabdid was so greedy and knew that Bob Johnson had a whole list of sponsors for the Juneteenth, and he wanted to get his hands on those sponsors. So I go to the hotel now, and Bob Johnson is there. Jabril is there. When I left the meeting with Papa Sunday, coming to the hotel, that's who I ran into, Bob Johnson and Jabril. And that's when they started telling me, yo, man, them people been talking dirty about you. So now when I was upstairs in the hotel room with His Excellency, with His Royal Highness Papa Sunday, I asked Papa Sunday if he would come on the production the following Thursday. Okay, the Van Miller Talk Show, I Found My Voice, which His Excellency Ambassador Abdul Bey has been on the production. It will be on tomorrow, and you can too. So now, Papa Sunday said, yeah, he'll come on that Thursday. So I did. I took some pictures in the hotel, took some video in the hotel, put together a couple of production trailers for the program. And when I leave his room, I run into Bob and Jabril, and they start telling me all the negative stuff Numa was talking Papa Sunday about me. So now I leave the room, I leave the hotel. That Thursday, that following Thursday at 8:30 in the morning, I call His Royal Highness Papa Sunday. In the meantime, that Wednesday night, the Nachir and the ancestors, the Netaru, kept talking to me all night. All night, they would not let me sleep. They telling me that His Royal Highness Papa Sunday is not coming on the show. I heard that clearly. I got the message clearly. Waking me up out of my sleep every other hour or so. Okay. 8:30 in the morning, I get on the phone, call His Royal Highness Papa Sunday. I say, Your Royal Highness, Uduma Akiyo, doing the shit. How you feeling this morning? I'm calling to confirm that you will be on the production at 12 o'clock. The brother told me, no, he's not coming. I said, I know. I already been told you weren't coming. I said, the Netaru and the ancestors and the chair told me. They kept me all up all night telling me you're not going to come. He said, well, after he left my hotel room, I started getting messages from Muabdid and Numa telling me all kinds of negative stuff about you. Why? Because I speak my mind. And I said to Muabdid in front of everybody, you're doing something you don't need to do. You need to do it a different way. He didn't like that. I don't care if he didn't like that. I don't care if nobody liked what I say. I'm going to say it anyway because it needs to be said. You a man, I'm a man. We can look each other in the eye and express how we feel and get things done. If you can't do that, then you can't tell me you a man. You can't tell me you a man. If you can't take a man's criticism or you can't criticize me and I say, oh yeah, brother, you're right. Forgive me, let's move forward. You can't do it like that. I don't need to be around you. That's why I left. When they kicked me out, I didn't have a problem. The brother that kept me in is the brother on the phone with us right now listening. He and the other brother. So now, and the reason why I said what I did to His Royal Highness Papa Sunday is because in the culture, they know when the ancestors speak to you. They know when the spirit speaks to you. They understand that. So that's why I said that. I wasn't trying to be impressive. I wanted to make sure that he knew that I know what the spirits do with our people because I experienced that. I experienced that. I met a brother who came to the first Economic Development Summit at the headquarters of the African Union. This brother, His Royal Highness, King Joseph Du Bois, a direct descendant of W.E.B. Du Bois. He and his wife, Queen Lavinia Du Bois. I got their pictures. He was the honorary chair along with Dr. Okika, who is the educational director for UNESCO for the Sustainable Development Goals. Dr. Okika, a very good friend of mine. She and His Excellency, His Royal Highness, Joseph Du Bois, were the honorary chairperson of the first Economic Development Summit. So now, that brother told me one day, he asked me, he said, brother, what's your name again? I said, Makakuvu. He said, that's a very interesting name, very powerful name. Then he says this, I ain't nothing to say about what he said. He said, God speaks to you in your dreams. That's what he said. I didn't say nothing. So now, They kicked me out. They go to do everything that I said for them to do when the Royals got here. Take them to the place I told them to take them to, but they refused to want to do it with me, but they went there anyway. So anyway, I turn around and do the Economic Development Summit in October. And I'm sharing this with you so you know how deep my roots go with the Ateker Kingdom Alliance. So now, Ambassador Opalak, after they see that I bought in the tractor company, after they see that I've been able to do something that they themselves did not think I would be able to do. When the brother mentioned to me Tough Build Tractor, he said this to me. It wasn't Ambassador Opalak, it was another brother named Sebastian. He says in the WhatsApp group, oh, brother, I know you got some money stashed away somewhere. I need $60,000 so I can buy a Tough Build Tractor. I said, brother, I don't have $60,000, but what I will do, I'll contact Tough Build Tractor. So I asked him where it is. He said they're in Nebraska. I said, I'll get in touch with them and see if they'll come to the summit. Oh, no, they're not gonna come, don't do that. And I fought with this brother for almost 6 weeks, moving forward. And when I got the commitment from Tough Build Tractor to come, and the brother came, and the sister, the woman brought her tractor with her nephew, who they're still tied right now with what we're doing. The brother, Ambassador Opalak, said to me, they didn't think I was going to be able to do that. That's exactly what he told me. And then we had these conversations. In November, he sent me an outline about the convention. We had a phone conversation about the convention that we're planning right now for this September coming. That's going to be held in Atlanta and in New York during the last week of the United Nations General Assembly. He sent me an outline specifically addressing me being the point person to set up the convention. I had a conversation with him. I followed that up with a document based on the conversation we had on the telephone to move forward with this. I said to them, I need from you to represent the Ateker Kingdom Alliance a letter of authorization and appointment, official identification, and an operating budget and remuneration. All of that's outlined in the document based upon our telephone conversation that I followed that conversation up with a written document. To this day, I haven't gotten none of that. In the foregoing conversations we've had, I mentioned that because there was a conversation, well, should we do a non-for-profit or LLC? I told them, I said, we don't need a non-for-profit, we need an LLC. Ambassador Oplong set up the LLC. The LLC is an independent entity from the Ateker Kingdom Alliance. It is the Ateker Kingdom Alliance LLC. That is the entity that is responsible to organize this convention, and we're moving forward. So that's my involvement with the Ateker Kingdom Alliance and how deep the roots go. At this point, I want to yield to Ambassador Oplong so he can give you a brief background on the extent to which the Ateker is becoming to be a foreboding entity coming out of the continent of Alkebulan. I yield to you, Ambassador, to speak. Are you still there, Your Excellency? He might have dropped off because he has an early morning. He works in a hospital. So in any event, the Ateker Kingdom Alliance spans over 750 kingdoms in the
Still
country.
on.
I'm
He's still
sorry?
on. He hasn't dropped off. I see his picture. He's still on.
Okay.
So he might have stepped away, but he didn't
Yeah, he
drop
may
off.
have. Oh yeah, I see his picture as well.
All right.
Ambassador O'Prong, you still there? He gets up early, so he might have dozed off with
He might
his
have dozed off. All right.
But the Ateker Kingdom Alliance, 750 kingdoms and growing, their primary location is on the east coast of Alkebulan, from Uganda, Kenya, Ethiopia, Sudan, and South Sudan, where they're fighting right now. And the Congo, Burundi, Rwanda, to a lesser extent. And they're growing with other kingdoms coming on board. Their roots, as I said, go back to ancient Kush, Meroe, Nubia, Numidia. Hannibal come out of Numidia. Hannibal was a Moor. Numidia is where they use the term Mori Amazi. So with that, brother, I just wanted to share with you what is on the table, what is forthcoming. And I got to say this: Moors unite or perish. Which do you choose? That is the title of the production tomorrow. Moors unite or perish. And with that, I yield for any questions, because I've already talked for about an hour. Brother said I had an hour. So before I sign off, any questions, comments, or
We're going
concerns?
to fill some questions about this stuff. What, 10, 15 minutes for questions? Questions, anyone? Ask your questions to dear old Captain Noah. Send them down. Any questions? Questions, y'all.
Hey, all I can say, if there's no questions, man, I must have answered everything before anybody
Yeah,
asked it.
Yes, yes. No questions? They usually some when I do this for my
I gotta say, man, when you're real, nobody can answer a question when you're real about it. Keeping it real, that's all. They can't answer a question. You keeping it real. It's real.
Doing the chair, brother Udama Akiyua. Doing the chair. Well, brother Ambassador, Your Excellency, Brother Bey, Abdullah Bey, please, I'm gonna resend the channel. You already got the link for tomorrow's
it's in the
production.
chat. It's in the chat.
Solid.
We put it in the chat.
Solid.
It's in the
So
chat, everyone. The link is in the chat for tomorrow, 12 p.m. Eastern Standard Time.
solid. And I'm gonna send it. I'm gonna text you the
Father and
channel.
myself will be discussing unite or perish. Which one do you choose?
And I'm gonna text you the channel again to your cell phone, so you can share that as well later on with the productions on it, the Odyssey channel for WMCJL TV.
All right, because we have the write up with the Van Miller. I think that's already on the.
Right.
It's in the chat. All that thing is in the chat.
All right. You got the production trailers
It's in
for
the
tomorrow.
chat. Yeah, Thursday, April 27th, 12 noon, WMCJ LTV, Telegram Network, Van Miller Talk Show. I found my voice, and then they had the link. Yeah, we got it.
All right, brother. Doing the chair, I want to thank everyone for your invite. And I'm also known as Makakuvu the Moor when I perform. That's my stage name. I'm not an artist or a performer. I'm a Tebna chair, a spiritual drummer. And when I drum to lift the spirit and to bring down the ancestors. And I had a sister one time, she asked me, said, why you wear the African clothes when you drum? I told her, well, because I sweat. And I don't want to wear my decent clothes to sweat in. So I wear the Grand Buba Dashiki. And she looked at me and she said, oh, I thought you wore them because when you drum, the ancestors come around you. I said, what do you mean? She said, I saw them around you when you were drumming. And that's the second time I had that experience from somebody. I was in Brooklyn one day years ago, and I was speaking to the brother about the pentagram decades. The pentagram decades are the first 5 decades of any new millennium. And I was explaining to the brother that the pentagram decades, each decade has a name. For example, from 2000 to 2010 was the decade of enlightenment. And enlightenment, as attested to the discovery of the grand unified theorem, or the theorem of everything, which was what Einstein was looking for when he died. He didn't find it, but His Excellency, Professor Gabriel Oyibo, discovered the grand unified theorem. And I had the honor of opening up several of his lectures with the drum. I got that on tape too. But in any event, so that was the first decade, the decade of enlightenment. The second decade of is the decade of redemption, as attested to the the prophecy of the birth of the white buffalo. The prophecy of the birth of the white buffalo says that beware the birth of the white buffalo, because the birth of the white buffalo is a sign that mankind has until the 21st day of the 21st year of the 21st century to redeem himself before the great purification. See, because redemption is not for us. Redemption is what the Moors are supposed to be doing, lifting fallen humanity. But instead of the Moors doing it, you got the Shriners doing what the Moors are supposed to do. The Shriners got the hospital. The Shriners are lifting fallen humanity on their side. They're doing the work that we're supposed to be doing, and we too busy trying to figure out how to unite. That's why I say Moors unite or perish. The third decade is the decade of, you got redemption. The fourth decade is the decade of manifestation. Yeah, the third decade is the decade of manifestation. Manifestation means, for example, in the decade of redemption, there were 2 major earthquakes. The one was at the beginning in 2011, which was the earthquake in Haiti, killed 250,000 people. People, oh my God, we got to go to Haiti. We got to help Haiti. The decade of manifestation means that during the decade of redemption, all those things to lift humanity is supposed to manifest itself in the decade from 2020 to 2030. So we should be looking at the beginning of manifestation amongst our people, which is why we are working on the Ateker Kingdom Alliance. This is manifestation, brothers. The fourth decade is the decade of judgment. From 2030 to 2040, the decade of judgment. Ma'at. The fifth decade from 2040 to 2050 is the decade of retribution. You reap what you sow. The sixth decade is the dawn of the mind-free consciousness. So the pentagram decades take you to the decade of retribution. From 2050 to 2060 is the dawn of the mind-free consciousness. And when you correspond that to from 4,400 BCE to 2023 AD, you get 6,262, going to 6,263, going into, which is 37 years from 6,300, which is the Kushite Kemetic cosmological birth cycle of the Ma'at dawn, because 6 and 3 is 9, representing born. And when you have 6,300 on a cosmological level, you're talking about a tremendous amount of vibratory frequency when you address the vibratory frequency of the 7 principles in the Kabbalion. We'll talk about that another time, brother. But that during that explanation to the brother, I was explaining about the pentagram decades. The brother says to me, I saw him close his eyes and he fell back. And I hadn't even gotten through the decade of manifestation. And I said to him, oh, you're not listening. You don't want to hear this. He said, no, brother, that's not it. He said, while you were speaking, I heard the African drum, and I heard the indigenous drum. And that's why I fell back, because that vibration was so heavy on me. And that was the first time that somebody attested to those spirits. The second time was when the brother said to me that God speaks to you in your sleep. And then the third time, when the sister said, when I watched you drum, I saw the ancestors stand around you. Udama Akuyua, dew in the chair, lion of the new dawn, the vibratory frequency of spiritual liberation. I thank you all. I thank you all. We're going to put this tape on our channel as well, brothers. Tomorrow.
Yeah, Terrence gets it done. I'll send it to you. Yes,
thank you,
absolutely.
brother.
Thank you, Makakuvu, for joining us and for giving us that great explanation. I learned, because I didn't even know all that background about you. So it was a treat for me. Thank you.
Like I say, there's some things we call it one of a kind. So you better welcome aboard, because we consider one of a kind. So are you.
Dew in the chair. Moors unite or perish. That's the manifestation.
All right. So we're gonna close out.
Thank you.
Yes. So before we close out, all right, so this is chapter 8, Shem Malachi Bey. All right, chapter 8, Moors and Masonry part 2. All right, chapter 8, once again, Moors and Masonry part 2, Shem Malachi Bey's proposal and plan for the restoration of Moorish national political unity based in the ancient, well-settled international principles of restoration of post-millennium, reversion to sovereignty, and the recovery of lost sovereignty. Primary goal, resuscitating the Moroccan Empire out of her 200 out of her political coma, prolonged unconsciousness, political inactivity, and absence from the family of nations, bringing the Moroccan Empire out of a 200-year period of political collapse, disintegration, dismemberment, and the absence from the family nations due to European conquest, subjugation, slavery, colonization, captivity, bondage, and the mass denationalization of the native Moors of the land, the restoration of the Moroccan Empire to the independence and full sovereignty, and through the enforcement of post-millennium. I thank you again. To go to moorsandmainstreet.org to get my books, Moors and Masonry Part 2, Moors and Masonry Part 1, Masonic Conference Square and the Connection of Measurement and Timekeeping, how Venus and Moon rule, Illuminati, Illumination of Mind, Etymology and Vocabulary, Submit You 1. Don't forget to hit the notification button, like and subscribe, Moroccan Post, media YouTube page. This will be uploaded. All right. Tomorrow, this is once again, I want to thank Makakuvu for joining us. Thank you very much again, brother. Tomorrow, 12 noon, the link is in the chat. All right. More unite or perish. Unite or perish, which do you choose? myself and Hammurabi Bey will be presenting tomorrow, 12 noon Eastern Standard Time. The link is in the chat, and share the link and post the link. All right, we'll see y'all tomorrow at 12 noon Eastern Standard Time. Unite or perish. Thank you again. Once again, Moroccan Post Media YouTube page. Link, like, subscribe, and hit the notification button. Thank you, everyone. Peace. Assalamu alaikum.
Thank
Peace.
you. Walaikum salam.
Thank you.